you've dealt with. And you've been involved in the statement of case, statement of common ground, and your proof of evidence, obviously. And you visited the appeal site back in June of this year. That all correct?
Yes.
And then you tell us at 1.9 that the evidence that you give, prepared and provided, is true to the best of your knowledge, and confirm that the opinions expressed are your true and professional opinions given in accordance with your professional standards and code of professional conduct. Again, and all correct?
Yes.
Wonderful. Okay. So let's start then with the topic one, the determinative question for this appeal, what the inspector actually has to sit down and think about once we close on Tuesday. Policy S1 of the local plan, if we can start with that.
Mm-hmm.
And it is on page 14.
Yeah. 14, yeah. Yeah, the first policy.
The first policy.
Yeah.
And I think it's agreed, it's common ground between you and Mr. Tate that this reflects the presumption in favour of sustainable development in the MPPF, and also the test in 38.6 of the Planning Compulsory Purchase Act and the tilted balance of paragraph 11D of the MPPF. Is there, what's your view, please, on whether this policy is an in-date policy, given the 5-year housing lands plan?
I think in terms of the 5-year housing land supply position, it is, whenever we're assessing whether this is in date, yes, it is. It directly reflects back to the MPPF position on presumption of sustainable development. Then in the later second kind of part of the policy, below the 14 criteria, it's almost verbatim complies with and reflects 38.6 and the requirements of the tilted balance.
Thank you. And are there any particular aspects of this policy that you would ask the inspector to have regard to?
I think specifically we have point 10 in terms of conserving and enhancing the historic environment, and then point 9 of the natural environment as well, which leads to our kind of in line with our landscape proof and part elements of our historic, our heritage evidence within my proof.
Thank you. And in terms of, you would have heard how I put it in opening, is there any dispute between you and Mr. Tate that the determinative test here is whether the adverse harms of granting planning permission significantly and demonstrably outweigh the benefits?
No, given the 5-year housing land supply position, the tilted balance is engaged in 11D part 2. There's no disagreement there.
And I just wanted to pick up on a point made in the appellant's openings about the council being close to being in special measures. Do you remember
yes.
The point that was made by Mr. Hawley there? Firstly, your view on is the council in special measures, and or secondly, what is, if anything, is the relevance to the inspector's decision here of them being close to special measures?
But kind of echoing what Mr. Hawley said, that they were close to, therefore not in special measures. And then in terms of how that should affect the inspector's view on assessing the appeal, I don't think it should be given any weight whatsoever. The special measures are due to procedural failings and kind of the quality assurance statistics of local planning authorities' performance. They are currently not in that, so therefore it shouldn't be given any weight, in my view.
I suppose it might be said that, you know, some authorities end up in special measures because of the amount of decisions that are being overturned effectively on appeal, and that I suppose the inference might be that indicates that the quality of decision making is poor. is that a blanket assumption that you would apply?
No. Again, the council is not in special measures. I don't think that this is the case here. We find that the local authority has appeals relating to 5-year housing and land supply positions, and planning judgment applies in the tilde balance for all of those. But fundamentally, we're not in special measures here.
Thank you. Okay, let's turn to the next broad topic, which is the benefits, but need to feed into that overall question. A point of dispute between you and Mr. Tate is the weight to be given to delivery of market housing as a benefit. Mr. Tate gives that substantial weight. You give it significant. You just summarise for the inspector where that difference of opinion comes from.
So, whenever we are looking at the weightings associated with market housing, we consider it to be significant. We accept that the 5-year housing land supply position is what it is. We are below 5-year housing land supply at the time of the decision. The council had recently, or was about to accept, a 4.2-year position, and that is what's publicly available. However, following the proof of evidence supplied by Councillor Fittick, it's the council's position that it's 4.04 years, and Mr. Pycroft's evidence that it is 3.6. Fundamentally, there's no kind of difference in bridging. But whenever we look at the delivery of housing, we see there is, granted through some appeals, a slight upward trajectory. But fundamentally, the position is that we're in a materially stronger position than previous appeal decisions such as Homefield, where there was a 2.7-year supply and it was granted substantial weight. But we're now in a materially stronger position, and we can see that that is a position that significant weight should be granted. And that has been echoed by the recent Land West of Cemetery decision, where very similar housing land supply position was found. It was only decided a couple of weeks ago. And the inspector considered that the supply of 275 dwellings on the edge of a settlement also was only granted significant weight. That is my opinion. That's given the fact that it's 110 homes, and it is granted significant weight in my view.
Sorry, Cemetery Road.
Land west of the cemetery. That's the land west of Malden.
The Malden.
Yes.
Yeah. So the inspector in that one said it was significant, not substantial.
Yes.
Yeah. Okay.
And that is set out for clarity. Let me just find it. In paragraph. Where is it? Just double check this is the right one. Paragraph 75 of the West of Malden appeal.
That was allowed, wasn't it?
It was a lot, yes.
It was allowed, but he still found it to be significant, not substantial.
Yes,
weight.
that's correct.
And the housing land supply was the same as your.
There was a very, very minor difference. From my memory, it was I think it was declared as 3.9 or 4 from the council's position, but Mr. Pycroft, who acts on behalf of the appellant, acted on behalf of the appellant there, which was LSL Capital, I think the name of them was, and Mr. Pycroft had a largely similar position in his evidence as well. So there's been no fundamental change between this appeal and that appeal, but now we also have to consider that 275 homes have been allowed recently, which means that there is a difference, though we haven't agreed what that 5-year housing land supply, the effect of the West of Malden appeal would have on the 5-year housing land supply position between the parties. We can accept that that it doesn't kind of materially change the approach, though we have to accept that number of 4.04 years or 3.6 between the council's position and Mr. Pycroft's position in relation to this appeal would be affected by.
Yeah, but you haven't.
We haven't
factored it
agreed.
in.
We haven't factored it in, and I'm not suggesting we should at this stage. In terms of agreeing a new 5-year housing land supply position.
And just
That was recently, wasn't it?
That was allowed on the 6th of July.
Yeah, 6th of July. Yeah. Sorry. Yeah.
sorry, no,
they-
just for your note, it's paragraph 47 of the inspector's decision sets out the respective positions on land supply. It was 3.52 years for the appellant versus 3.97 for the council.
Yeah.
So it seems that maybe there's something in a couple of weeks that has passed that has shifted that very slightly upwards for both parties, but there's nothing material. Well,
Nothing. In my view, there's nothing materially different between 3.97 and 4.04 and 3.57 and 3.6.
Yeah. So anyway, that's basically why you say significant and not substantial, which
Yes.
they say. Yeah. Okay. Fine. Yeah. Okay.
And then turning on to the next benefit then, Mr. McGarity, which again you and Mr. Tate agree is obviously an important benefit here, is the affordable housing provision.
Yes.
Same question really. Mr. Tate says substantial weight, you say significant. Where does that difference come from?
Again, we accept that there is there needs any kind of major planning permission is required to supply affordable housing. It's enshrined in the policies, it's enshrined in the ambitions of the MPPF. However, we find that given the trajectory and the recent kind of delivery of affordable housing in the district, that weighting does slightly become significant. It is fundamental that to understand that this, where we see differences in other recent appeals, it is whenever appellants have gone above the policy requirement in terms of how other inspectors have given weightings. I think we see here that there is a 30% requirement as per the policy. The policy sets out differences in different locations, different affordable amounts are required, and in Southminster, in this location, only it's a requirement of 30%. This is a policy compliant scheme in that regard. There's no dispute there. But in terms of the benefit weighting, we can give it significant. Again, that is further echoed in the West of Malden appeal, where they were also policy compliant in terms of provision and in terms of mix. And we find that is set out in. They also gave significant weight. That is set out in paragraph 76 of the Land West of Malden appeal, West of Malden appeal.
Thank you. And in terms of the policy requirement that you referred to, is that from policy H1?
It is from policy, yes, H1. So.
Just for, I don't think there's any dispute between us as to what that requirement is, but just for the inspector's note as to where that comes from. Economic benefits. Then, oh, sorry, I'll let you find.
Yeah, just to absolutely confirm. Yes, so it's set out in policy H1. There's a table which sets sub-area requirements.
Where's that? Sorry.
Policy
Page
H1.
82. That's the PDF page. Which helpfully is the hard copy page as well.
Yeah. So which sub area is this in?
So just to get the absolute. So we sit in sub-area of rural south. Rural south east higher. Rural south east higher.
Yeah. Malden rural southeast higher, 30%. Yeah. Okay.
Yes.
Fine. Yeah. Sorry, economic benefits. Yeah.
Another point where there's a difference between you on, again, I mean, just on weightings rather than it being a benefit. Yes. You've said moderate, Mr. Tate says significant, the difference being...
Though we accept there is with housing development of any kind, there is going to be economic benefits through. I think some of the examples given are council tax benefits. I think there's over a 10-year period, £2.1 million was referred to in Mr. Tate's proof. Construction, jobs, employment, spending money in the local area through in services and. But fundamentally, in this case, the benefits identified or set out are just the benefits that you would find in any scheme. There's nothing kind of above and beyond the normal. There's the norm. We're not providing any on-site jobs. We're not providing in terms of uses, and we're not providing anything else above and beyond what would be expected of any 110 unit housing scheme on the edge of a settlement within Malden. It is very much the benefits are what linked directly just to normal household expenditure. So it's not going above and beyond. And again, that is something that we find in the land west of Malden, that moderate weight was given to that, is my understanding as well.
Cemetery Road scheme.
Cemetery Road, yes.
So is your point regarding this that if it was housing on a site that the council were happy with and that it complied with its spatial strategy, say, then would you attribute
I wouldn't attribute any other weight in terms of the economic benefits.
So wherever it was, it would just be moderate benefit.
Given the nature of the scheme, it is in relatively close proximity to the town centre. As you say, it's on the edge of the settlement. If we were to say it was, let's say, on the edge within the settlement boundary, my view is that the economic benefits would be the exact same.
Okay, so it's yeah. Oh, fine. Okay, fine. Yeah. Okay.
Your point being, as I understand it, that these are the benefits that flow from any housing development. The economic statement that Mr. Tate refers to, I think it's called document 1.8, is identifying benefits that would flow from any housing scheme. There's nothing here that goes above and beyond that, in your view. And just for your notes, sir, it's paragraph 79 of the land west of Malden. I keep calling it land west of Malden. I think it's just called west of Malden. But
just refer to it Cemetery Road. I know
Cemetery Road. Okay.
Yeah.
Where you get used to
paragraph 74.
79.
Yeah.
And again, that was for a larger scheme as well, which would have.
I've sort of I've read the summary of that. I haven't read the whole thing.
Of course, that's fine.
Public open space. Again, there's a difference, but again, an acceptance that it's a benefit, but a difference between you as to the weighting attributable to that. You'll know the question by now. Where does that difference of opinion?
Well, I think
what's the difference? Sorry.
The difference is, I believe. Well, you tell me, Mr. McGarty, what weight you've given to
I've given it limited weight.
Limited v moderate.
Moderate is my understanding. Yes, because again, given the location, and granted, this is an outline application. The reserved matters are due to come, but whenever we see the requirement for BNG being incorporated, you usually find that the green spaces tend to be not, again, this is subject to a detailed design, but they need to usually be in one big location to get maximize benefits of biodiversity. I'm coming on to the point. And where we see in the outline proposals, the location of that public open space is at the northern part of the site. That is, in terms of accessibility to public open space, it's the furthest part away. It's the further within the site context to the rest of the settlement. It's the furthest away from where the access point to the site, and therefore it's also a policy requirement. For a scheme of the size, you need to provide that public open space as being, and it's not going, again, kind of, there's no kind of specific amount that is required, specifically set out by policy in terms of the amount, but my view is the accessibility of that public open space and the chances that that public open space will need to be located where it's located means that it's the most inaccessible point for the public to use said open space.
Yeah, okay.
Thank you. And again, the policy requirement, are you able to tell us off the top of your head which policy?
So I think it's one of the, I think it's D1 that it just simply says.
Take me to the page.
So it's policy D1, which is on page 48 of the document. I don't know.
D1, yeah.
Yes, and we can see point 2 in terms, it says provide sufficient and usable public amenity spaces, a green infrastructure and public and open spaces. There's no further detail qualifying the amount.
And then you touched on biodiversity net gain in your answer there, but that's another benefit, isn't it? That again, there's a dispute between you, not as to it being a benefit, but you say limited weight, and Mr. Tate says moderate weight. And I think, to be fair, the statement of common ground does say moderate weight. So why have you reached a different view in your proof? And
I respect that my view is different, and I apologise for that difference. But upon reflection and review of the position, in my professional opinion, given that it is simply kind of meeting and slightly exceeding the requirements of the Environment Act, the exceedance is 10.59, I think, in total. Therefore, it's slightly exceeding the legal requirement for a development of this nature, and it's a modest benefit to the biodiversity on the site in that regard. It doesn't exceed kind of, we're not supplying something like 20 or 25% BNG. It's 10.59. It's a requirement, and therefore I give limited weight to that. And furthermore, that is the same position the inspector came in the Cemetery Road appeal in paragraph 81.
And just in terms of what, obviously the appellants carried out an assessment of the potential for the site to provide biodiversity net gains. This is an outline application. In terms of what will be secured if outline planning permission is granted, what do you understand the level of BNG that will be secured by the permission would be?
Well, I think, again, it's the minimum requirement is set out by the Environment Act. The reserve matters application that will inevitably could result in a different level. I accept that, but what we have in front of us today is that the amount that they feel is capable with this outline layout is 10.59. They will be required to provide that under the current legislation. Granted, we've seen exemptions being introduced recently. This obviously they don't apply here, but should that become should they exceed the 10% BNG by a significant amount, then my weighting would change probably. But as it currently stands, we don't have that evidence in front of us today, and all I can do is give the weighting based on what is in front of me.
Thank you. Let's turn on to harms then, unless there's anything else you want to say on benefits.
Nope.
Obviously, one of the key harms identified by the council here is landscape and visual harm. We've had the roundtable session on that, and I assume that you rely on, and you tell us in your proof that you rely on and adopt the evidence of Mr. Friend. Anything that he said on Tuesday make you change your mind on
No, and I think we respect that the differences are purely in professional judgment. We completely accept the statement of common ground between the landscape experts that the methodology is fine. It is just purely a difference of opinion on some points where a moderate adverse landscape effect persisting at year 15 and the visual effects on users of rights of way remain apparent and obvious, notwithstanding the proposed planting. So I agree with what Mr. Friend's evidence.
And if the inspector also agrees with Mr. Friend's evidence, I mean, or indeed Mr. Holliday's, because Mr. Holliday accepts there will be a degree of landscape harm
Yes.
at a different level, what's the policy effect of that conflict?
So it would be in conflict with policy D1, and which is, in my view, consistent with the MPPF. Policy D1 sets out, just getting the specific point. So it must respect and enhance the character of the local context and make a positive contribution in terms of landscape setting and skylines, natural environment, particularly in relation to, we're not suggesting it's a non-designated site of biodiversity geovalue, but the natural environment there, but the landscape setting, and that would be the policy conflict. And fundamentally, it is an urbanization of what is an arable field fixed beyond the settlement edge. And though we respect that it is purely professional judgment, where there is a dispute, my view is that the adverse harm caused to landscape and the visuals would result in a significant harm of the scheme.
Thank you. You've just talked about policy D1 conflict.
Yes.
I think in your proof
Yeah,
you
it's
refer also to policy S8.
Yes.
So is that
They largely, again, it has to do with kind of settlement boundaries. We accept.
we just go to that? Let's just bring it
So
up.
that is on page 45.
Thank you.
So within that policy, it sets out that the countryside will be protected for its landscape as well as its intrinsic character. And outside defined settlement boundaries, planning permission for the development will only be granted where the intrinsic character and beauty of the countryside is not adversely impacted upon. And I think that is a breach of this policy. That element of the intrinsic character and beauty being protected is though there is an element of this policy which I accept is out of date in terms of its housing function. Whenever we look at the paragraph 187B of the MPPF, that protection of the natural, the intrinsic character and beauty of the countryside is in date.
So I think that's a reference. There's a disagreement between you and Mr. Tate. I think you both agree that this policy is to some extent one of the policies that's rendered out or deemed out of date by NPPF footnote 8.
Yes.
But there's a disagreement between you as to its consistency with the MPPF, specifically the paragraph you've just referred to. The countryside will be protected for its landscape, natural resources, ecological value, as well as its intrinsic character and beauty. You've just touched on it then, but I think it's probably worth just setting out a little bit more. Why do you reach the view, I think it's at paragraph 3.14 of your proof, that this is consistent with the MPPF? And we can turn up that paragraph if that's helpful.
Well,
Point 14, yeah?
Yes, page 11. We're into hard copy page 9.
Yeah.
You say fully in accordance with the MPPF.
so yeah, I mean, whenever we think about applying those the the assessment criteria to assess whether or not a policy is out of date. Material weight can be given to it being in accordance with the ambitions of the NPPF. To me, 187, if we read it, saying that policy should, decisions should contribute and enhance the natural and local environment by, and then we go down to part B.
Are you in the NPPF?
Yes, of the NPPF. Recognising the intrinsic character and beauty of the countryside, and benefits from the natural capital and ecosystems, where we're not necessarily disagreeing, including that is purely in that intrinsic character and beauty of the countryside. The NPPF actually, in my view, goes to a slightly higher threshold where it says contribute and enhance the natural by recognising the intrinsic character and beauty of the countryside. That's what S8, if we jump back to that, also shares that ambition, and it says that it should not adversely be impacted upon, whereas the NPPF says that, granted, it says by recognising the country's size beauty, it does require an enhancement at the start of paragraph 187. So my view is that it is the policy is in accordance with the NPPF, and that element of it should be given weight.
The level of weight which you attribute to the landscape harm overall?
Is significant. I respect that we are not, if we then compare to the home field appeal, where that Taylor Wimpey appeal, it was given very substantial harm. We are not, which is the other side of Sheepcoats Lane, which was referred to by the landscape experts. I accept that we are not protruding into the countryside in the same level. I accept that the density and design of the schemes are different. They're fundamentally different sites as well, with different landscape effect. That will have different landscape effects. So therefore, I have not gone to substantial or very substantial harm, but I do think that the effect will be a permanent urbanisation of an arable field, which will be has, if we accept Mr. Friend's evidence, adverse effects on the landscape and visual of the
Thank you. Another key harm that the council has identified is obviously to the living conditions of occupiers at number 48, and we heard the noise evidence from the experts yesterday. Mm-hmm. Again, do you adopt the evidence of Mr. Bryant in relation to those issues?
I do.
And what, in your view, what are the policy implications of the evidence that he gave yesterday in relation to noise impacts?
So, in terms of policy breaches, policy D1 and D2, they again, page 48 of the for D1 and page 50 of D2, they provide their amenity policies, and we accept that this is one property that is having that effect on, that is being affected in this harmful way. But based off the only noise monitoring data that has been provided of that northern facade, I think we heard quite clearly yesterday that Mr. Bryant had concerns that this would have that significant effect on number 48's amenity, and it would have to change their behaviour, though we respect Mr. Healy's evidence, and that is a point of dispute. We view that Mr. Bryant's evidence is as accepted in our view, but the point is that if we do accept Mr. Bryant's evidence, he sets out that there are going to be times where, and we saw Mr. Agarwal here yesterday, who was deeply concerned that it was going to change his behaviour. We then have to take though there was a lot of technical assessment yesterday, some of it, lots of numbers flying around. The point is that the only person who can set out what their behaviour is the resident. Behaviour is intrinsically personal, and he strongly suggested in his objections to the scheme and his further objections that have been submitted as part of this appeal and the representations that he made, it was clear that he was deeply, deeply concerned by the noise effect, and only he can really assess and set out what his behaviour is to establish that baseline if there's going to be a change. I think the idea that cars driving past the window, and granted the road can be changed, I appreciate that this is an outline position and the effects are directly linked to the road noise. Whenever we take a practical view of cars going past his window at approximately 11 metres away, the suggestion that they wouldn't result in noise that could affect him if we were using Mr. Bryan's evidence of that LA max position. I think that I accept Mr. Bryan's evidence, and I think that it's quite clear that there is going to be significant effect on number 48's behaviour, therefore in breach of policy D1 and D2, which I give full weight.
And you say full weight to D1 and D2. What is the weight that you attribute to this harm overall in your planning balancing?
Granted, whenever it's assessed against what the scheme is for, whenever we look at 110 homes versus the effect on one property, granted, though I think the effect on that property does meet that significant threshold that was discussed yesterday in the PPG. I give it moderate weight because it is only for one property against 110 homes, and I think that's a reasonable position to hold.
Thank you. The other aspect of the amenity concern that the council has relates to the acoustic fence, and you address that in paragraphs 4.39 to 4.43 of your proof, and that is on pages 19 onwards. Yes. In the hard copy. Now, there's obviously a slight dispute on numbers, and we've had some discussion around it. But just to clarify, your assessment was based on a 2 to 2.5 metre fence. Is that right?
That's correct. That was in the committee report.
Yes. And are you able to give any more context to that beyond? You obviously took it from the committee report.
Yes. So in conversations with the case officer, Mr. Chris Purvis, there was never any written recommendation from the EHO that was the amount, the height that it needed to be. Those were just conversations they had that was then committed to the committee report. My understanding, and through my discussions with Mr. Purvis, was that was a phone call with the EHO, which they said it will likely have to be somewhere between 2 to 2.5 meters. It was then reported as such within the committee report. Now, through the evidence that we heard yesterday, obviously the two parties are in dispute as to the noise effects and therefore the level of mitigation required. Because of that, and in accepting Mr. Bryan's evidence, his evidence yesterday set out that the 1.8 metre fence will probably not, or will not, mitigate against the harms to the first 4 windows. I think one of the points I would like to highlight is in that evidence, Mr. Healy often included 15 dB reduction for partially open windows and was never really elaborated on the effects. It didn't include the effect of fully open windows, which during a heat wave could happen regularly, quite often. But then he also never said that we should absolutely disregard LA Max effects. It was asked directly of him a number of times. But going back to the fence, my view is based on the evidence in front of me, that this could be the height that the fence would need to be to mitigate any harm, at least, that could have an effect. However, that would have a negative effect on the street scene, having a fence that is up to 2.5 meters, and that is only theoretically, because we don't have the detailed design, which granted will be left for the reserved matters. And we, if should the road move, we accept that the level of mitigation would be affected as well. So we don't know how high, in reality, we don't know how high that fence is going to be because they haven't got to that reserved matters stage. But based on the evidence in front of me, if a 2 to 2.5, particularly if a 2.5 meter fence was introduced in that location, it would have a harmful effect on the immunity, because it would be on the street scene, because it would be compounded by the fact that number 46 would be demolished. It introduces this this new kind of almost stopping point to the existing housing within along Queenborough Road, and you would have a brand new estate which that fence could essentially, in design terms or in street scene terms, add a new kind of focal point, as it were. But fundamentally, we don't know how high that fence is going to be, and so therefore, in my harms, I give that limited weight.
And just
Limited weight to the harm of the fence.
Yes. Yeah. Again, I accept that it is a fence in a location where there is already a fence. But if we were to introduce a fence that is 2.5 meters high, then that is a kind of material change to the street scene, which, granted, when assessed in the tilted balance, I give limited weight.
Okay.
and Mr. Tate has assessed on the basis of a 1.8 metre fence, and you've seen that depicted in Mr. Holliday's Appendix 2, what that fence might look like, and that's the basis on which the appellant has proceeded. As far as you're aware, is there anything securing a 1.8 metre fence?
No, there's nothing. We don't have an agreement in place on that fence yet. Again, it'll be directly. I know that we are drafting. We're talking about conditions about that, and I think what we have is a point of dispute regarding the noise effect. The acoustic fence will be directly linked to what noise evidence is accepted. We should in reserved matters stage the appellant need to or would keep the road in its current location. Mr. Bryan's evidence does suggest that 1.8 meters wouldn't be high enough, so the condition would need to reflect that change for the fence. But my view is that we don't have any kind of complete control of the fence as it currently stands. The condition is in drafts, granted, but if it doesn't mitigate against the harms caused, then it's not a suitable height of fence.
Understood. Ultimately, as you've said, you give it limited weight. So if the inspector was satisfied that, or if it were made out that it's a 1.8 metre fence is what's required, do you have any concerns over a 1.8 metre fence?
No, again, there's a 1.8 metre fence there, and it does, but it does currently go lower as you get closer to the to Queenborough Road. It's 1.8 meters from, I think, roughly about the start of the facade, or the start of the elevation of the property. But if that was to be replaced by 1.8 meter fence, it would be unreasonable to consider that harmful.
And if you take that limited weight out of your overall planning balance, what's the effect?
There's no significant effect in my planning balance.
Heritage harm, then, agreement between the parties that we're concerned with a low level of less than substantial harm, yes. And that therefore the so-called, if I can call it this, heritage balance, I'm not sure that's, as some people refer to it in paragraph 215 of the MPPF, And that's also reflected, I believe, in the local plan policy.
Yes.
Is it D? Which policy is that?
So that is in D3.
Thank you.
So that is page 54 of the local plan.
So that requires us obviously to weigh the heritage harm against the public benefits of the proposal. Now, you've addressed this in, I think, 3 places in your proof of evidence, but there appears to be some inconsistency. So could you just help the inspector with what is your position as of today, or just what is your position that you're putting forward to the inspector as to whether the heritage harm is outweighed by the public benefits here?
Yeah, so firstly, apologies for the inconsistency. But
Take me to your...
Yes.
so the position I'm holding, I'm taking, and is on page 22 of my proof, paragraph 4.55. So they, though I appreciate that there is inconsistency, what I want to be absolutely clear on is that this we accept and has been agreed between the parties that is on the lower end of the spectrum of or the scale of the less than substantial harm, and whenever we assess that the public benefits of the scheme versus that level of harm, I can only conclude that the public benefits do outweigh the harm caused on that scale. So that is my position, that the in that heritage assessment of do the benefits outweigh the harms of the scheme in heritage terms? The answer is yes.
Can I just ask you a question on that? It's yeah, the test in 215. Do the benefits outweigh the harm? Do the public benefits outweigh the harm? But yet you still have to give it great weight. I find it quite hard to square that, because there seems to be a sort of inconsistency in policy. And I think you say that you know, in the overall tilted balance, you nevertheless have to give the heritage harm great weight, although the public benefits have already overcome the less than substantial harm. I always find that a bit
I think the way that
in my mind.
I agree. I think it's the MPPF could be kind of clearer on it, but the way that I've approached it in this case is that we have heritage harm and then planning balance, and that they're two. And whenever we assess the proposals in a planning sense and what the effects of the scheme would be, the proposals would have, we accept that there would be lesser substantial harm within the MPPF. That sliding scale isn't entrenched. It is either no harm, lesser substantial, or substantial harm. Those are the 3 levels. And what we have is we fall under that less than substantial harm. We aren't. I accept that the public benefits in terms of the harm are in heritage terms do outweigh. I cannot sit here and say that that whenever we're assessing it from purely a heritage position, that the impact on the setting, I think, of the roof of Spratts farmhouse is outweighed by the benefits that 110 homes would bring. I don't think that would be a reasonable position to hold. However, whenever, as you say, we still have to attribute great weight in the planning balance to it, because that's what the MPPF and MPPG instructs us to do whenever we find less than substantial harm. But given this context, we have given it limited weight in our planning balance, because, again, we accept that is on that lower end of less than substantial, but albeit we accept that the public benefits in that heritage element do outweigh it, but we still have to give it great weight.
Yes, yes.
Yeah.
You have to get. You've given it limited weight overall.
Overall, yes.
Overall, but you have to
Give it great weight in your assessment.
You have to give it great weight, although limited weight.
Yeah, I know it
doesn't really make sense to me. But
yeah, no,
but I understand you tried to square that circle yourself.
Yeah. Where I can, yes.
Yeah, sure. Okay.
So, anything else that you wanted to say in terms of harms before we pull that all together?
No.
Your view then, please, Mr. McGarity, on the compliance of the proposals with the development plan as a whole?
So we accept that that's given the 5-year housing land supply position and the age of the plan, there are elements of the plan which are out of date, and those points I believe are going to be policies S2 and S8. So, but primarily in terms of their housing function, those policies incorporate again, those points they're strategic policies, so they incorporate a lot of elements. They're not, but whenever we look at S2, I feel that again, it's kind of housing location function, but it still has weight in relation to enhancing the district's natural and historic environment in terms of S2. So that's because my view is that it is in accordance with the NPPF. Then in terms of S8, which for ease is on page 45, again, the settlement boundary point, we accept that where we're out of date, so therefore the kind of restriction on set out within that policy about insisting that everything will be within the settlement boundary, and the fact the council will support sustainable developments within those settlement boundaries. That is, we can't give any weight to that element, but whenever we can give weight to protecting the countryside, the intrinsic character and beauty of the countryside as well. And then within, we also have that's where we start with S8.
And obviously, you've been through and identified harms with various policies, but the inspector needs to step back and consider compliance as a whole. Do you consider that the proposals do or don't comply with the development plan as a whole?
I don't think they comply with the development plan as a whole, no.
So although S2 and S8 are out of date, all the policies that you've looked at, taking them all together, you consider that the scheme fails to comply with the development plan as a whole.
Yes.
And in your view, do other material considerations indicate that a decision to be taken otherwise than in accordance with the development plan in this case?
I think, again, we accept that there are material considerations as set out in the NPPF. We are in a tilted balance position, but I think at this stage we've got other decisions that we want to see consistency to a degree with, in terms of other appeals, but other than that, no.
And so the tilted balance, of course, is both another material consideration and also is entrenched in the policy, in policy S1 here. So coming back to that determinative question, do the harms, in your view, significantly and demonstrably outweigh the benefits?
Yeah, I accept that it's a fine balance in this case, but in my view, yes.
Thank you, Mr. McGarity. I have no further questions for you, but if you wait there, I'm sure others will do.
Shall we have a quick break? Yeah. Yeah, come back at 22.
Yeah, happy enough with that.
Yeah, yeah. You can obviously have a break over the loo if you want. Yeah, yeah, sure.
So Paulie's going to have a go at me, I guess.
Okay, Mr. Hawley, over to you.
Thank you, sir. Good morning, Mr. Garrity.
Good morning, Mr. Hawley.
Okay, I just wanted to go through your proof first, just so we know what we're dealing with, because
Okay.
I'll admit some parts of it I found slightly confusing.
Okay.
If we just look first, so I mean, I think some of it you've clarified in chief anyway, but paragraph 2.8, that's wrong. That's not your position. So you say there that the substantial.
Yes. So as clarified, 4.55 is my position.
So that's incorrect.
Sorry, say that again.
So 2.8
Yeah.
is incorrect.
That's related to the heritage harm. So as clarified in my evidence chief, 4.55 is the position I'm taking.
And then so I'm just trying to find the point. 4.55, again, this is to do with the heritage balance, and you say there it was a finely balanced matter in your written evidence. You know, I appreciate what you said to the inspector earlier, that you were talking about if you were weighing the harm to the setting of Spratts farmhouse's roof, or the appreciation of the roof against 110 dwellings, you couldn't tenably sit there and say that the public benefits didn't outweigh the harm at the lowermost end of the less than substantial scale. Yeah, I mean,
correct. That's what I said. Correct.
Yeah, so we can agree that actually the public benefits clearly outweigh the harm, don't they?
In terms of that heritage harm, yes.
Yeah. Okay. So, and then at 7:13, okay, so this is after you've been through the harms and the benefits, you're weighing these matters, you identified the tilted balance, and you say there, my professional judgment is that the adverse impacts of granting outline planning permission for this greenfield scheme in the open countryside would outweigh its benefits when assessed against the policies in the MPPF taken as a whole. Yeah.
Yes, it should say demonstrably, and
so that 7:13 is applying the wrong test, isn't it?
Well, yes, but and that was a drafting error.
Right. Okay. So we've got a few drafting errors in there,
Yes,
haven't
yeah,
we? Yeah. Okay. Early on in your examination in chief, you were asked about the council hovering near the threshold of potentially being placed into special measures, and you said, well, that's wholly irrelevant. And in answer to the question as to why the council might be in that position, you said it was purely procedural.
I didn't say
procedural factors was what you said, because I wrote it down.
Yeah.
Now, the reason that the council is hovering near the threshold for special measures is because at the last reporting date, 9.5% of its major appeal decisions have been overturned on appeal, haven't they?
Yes.
Yeah, so that isn't a procedural factor, is it? It's members or the council's decisions being found to be incorrect at appeal.
But Yes, but I don't see how that's relevant to this procedure.
Well, I mean, in terms of this particular case, we had a lot of reasons for refusal to start off with, didn't we? Yeah. And without anything at all from the appellant, and no change in circumstances, and no evidence provided whatsoever, a number of those reasons for refusal started to disappear, didn't they?
Yes, on our recommendation, because what we find was fundamentally we agree that members are allowed to have a different planning judgment than the planning officers. That happens up and down the country every day. Though, and they are with this, they were the decision makers representing the council in that case. We disagreed and thought that some of the reasons for refusal were not warranted or were not able to be defended. We then advised the council to withdraw a number of reasons for refusal, and because of that position, members are allowed to come to their own planning judgment, and I appreciate that we're not in disagreement with that.
Yeah.
But we advise that that there was reasons for refusal that were either not able to be supported by us or by any other experts, namely the transport reason for refusal, which we had a resident object to highlight yesterday, but on other matters we advised them correctly of which they did have grounds to refuse the application to which we are defending today.
Yeah, but I mean, reason for refusal 2, for example, which I think is the highways reason for refusal.
Yes.
You know, I appreciate the point. Members can exercise planning judgment. Our inspector here is going to exercise his planning judgment. You've exercised your planning judgment in the planning balance. But there are limits to that, aren't there, in terms of reasonableness and reasonable behaviour? Yeah?
Yes.
Yeah.
Yeah.
If an example would be where somebody claims to have exercised their planning judgment, but essentially it amounted to wholly unreasonable behaviour to come to the conclusion that they did, then that is grounds for a cost application, isn't it?
Well, yes. I mean, those are the requirements for a cost application.
Yeah.
Yes.
Okay. Planning judgment doesn't excuse everything, does it?
No, of course not.
No. And then members, for example, in terms of highways, had before them their expert consultee telling them that there was no objection in terms of highways matters.
Yes, and but they came to a different judgment, and we have advised that they don't defend that.
And likewise, in terms of air pollution, the appellant had provided an air quality assessment, the EHO had revised it, and members, in the absence of any other evidence before it, other than that it was acceptable, refused the application on that ground, didn't they?
Yes.
Yeah. And then without any more information whatsoever, other than being told that their decision was entirely unsupportable by any expert in evidence, the council withdrew that reason for refusal, didn't it?
Largely, yes, and the advice that we had given them.
I mean, that is unreasonable behaviour of members, isn't it? To come up with a reason for refusal that isn't grounded in any of the evidence before them, and then without anything more, at a later date, when an appeal has been made, say, actually, you know what, I'm not going to defend that. There's no basis for it.
Well, again, at the end of the day, what they decided on, I wasn't instructed on that at that point, so I can't speak to them.
No, that. You are a planning professional. You presumably work both sides of the aisle.
Yes.
You might be disappointed if you were promoting a scheme and all the evidence before members told them that it was acceptable, and nonetheless they decided, well, I just think it's unacceptable, and then you have to go to all the trouble of appealing, and they say, oh, I'm not going to defend that anymore.
Well, I think there's arguments that there are points where we use the noise elements as an example.
But we're here talking about noise. My example is air and light.
No, but what we have in terms of the noise, and again, this is not in terms. What I'm saying is, with the noise, there wasn't any kind of the noise surveys that were carried out didn't miss out key information at the time of appeal, in terms of, if we accept Mr. Bryan's evidence, which the council do, the northern facade of the building wasn't assessed. I think we can agree that with the Ward of Armstrong. I think that is in the noise statement of common ground. But what we're then saying is, they members didn't have that, and they came to that decision. Yet we have found through assessments that it was a reasonable position to hold. I think we can all, in terms of the transport, I can't defend that, and I won't be defending that. But I think it's not unreasonable to be concerned that the location of a access road, giving residents concerns, to suggest that the proximity to the home of 11 metres could potentially result in air quality harms in pollution terms, noise harms in pollution terms, and potentially lighting harms.
But it doesn't, does it? The council hasn't produced any evidence at any point, and nor has anybody else,
But
to support a conclusion from members. They refused it at the time without any evidence that it was unacceptable in terms of air quality and light pollution. And without anything more, several months later, facing an appeal, and presumably the council having gone out attempting to find witnesses to support these matters, found that they couldn't go witness shopping and find any evidence at all to support it, so withdrew them. That is classically unreasonable behaviour, isn't it?
I think that what to a degree, yes, I think that I wouldn't say it's classically unreasonable, because I think the grounds of which
you say it's unreasonable.
I think that it could be perceived that way. I'm not here to define whether it is or not. My view is that that is for the inspector, and if for any kind of cost application that you wish to proceed with, which is obviously the right of the appellant. But my view is that members, because there was, they felt that the proximity could have that harm on residents, and I don't think the suggestion that a new access road, having potential air quality effects and potential lighting effects, was necessarily unreasonable.
But they were assessed, weren't they? The air quality effects were assessed. That's the point. There was evidence. It wasn't a case of, oh, well, there's a new road and nobody's had a look at air quality. I'm a bit concerned. Is there an air quality issue? There was an air quality assessment with the application that said there is not an issue.
But then we also had, and again, I go back to the noise position, where
Why are we going back to the noise position? I'm talking about air and light.
Because what you're suggesting is that that basically refusal reasons on amenity grounds, and I know air and light, but we're not defending those. I can't speak for those, and we accept that they're not being defended. But the point you're making, in my view, is that members acted unreasonably on amenity grounds because they basically just didn't buy the evidence, or didn't want to buy the evidence, is what it seems like you're suggesting. Which, correct me if I'm wrong, please, but what we have found is that whenever scrutinised in terms of, again, the noise, that we have found in Mr. Bryan's evidence, that the quality of those assessments were in question. So at that point, the members were reasonable in that ground, but I accept that the council could have be perceived to be acted unreasonably in terms of the other two. So yeah. I do accept that. Okay.
And then in terms of noise, obviously we've had a procedural history to this. We've had our appeal. We've had everyone produce statements of case. We've had CMCs. For all the point about, oh, well, the council now have got noise evidence, the council had to go and find a witness, didn't they, to then provide a case? Because the council, even after the CMC, was unable to say what the issue was in terms of noise. The council didn't have a case at that point in time.
No. But the evidence has shown, and that we accept, that there was reason that reason could be supported.
Yeah. And then we know from yesterday's evidence that the council's case at its highest is now that, if it were to be accepted in full by the inspector, the council's evidence, and we've obviously had a discussion yesterday about whether it should or it shouldn't, but if it were to be accepted in full, then it amounts to windows on the rear elevation, an acceptable daytime noise environment. It amounts to, doesn't it? That's what we agreed in the noise evidence yesterday.
Yes, in daytime, yes.
Yeah. And if the intermittent events are such as claimed by the council's noise witness, then there may be a change in behaviour to close windows upstairs at night time.
Yes, which could result in that significant that
And,
crossing that
if
threshold.
all of that happens, you know, if we went through it yesterday, if the comparator that's used, you know, if Queensborough Road, where we know that the 85th percentile speed of vehicles was 29 miles per hour, is comparable to the internal excess road, which is designed for 20 miles per hour, and every car is a combustion engine car, you know, and the road is in the location ultimately at reserve matters stage where it is, then that's you know, that's the council's case at its highest, and your position is that once you distill all that down, there is a moderate harm to weigh in the planning balance. Yes, yeah, and if the council's case wasn't accepted at its highest, if it starts to diminish, that would affect the weight, and at some point the label might change, mightn't it?
Yes, absolutely.
Limited or to none.
Yeah, absolutely. Yeah, it would be unreasonable to hold any other view.
Yeah. All right.
Sorry, you said that's your case is that would be a moderate harm to weigh in the planning balance, and you said yes.
So in the planning balance, I give the effect on in noise and the amenity impacts on number 48.
Would be a moderate.
Would be a moderate harm because
Moderate harm,
though in amenity terms it could cross into that significant threshold. Whenever I engage the tilted balance, which is a different exercise, it's given moderate harm in my view.
Okay.
Okay, could I ask you to turn up the development plan, please? I suppose, you know, it's always funny, isn't it, inquiries, you get to effectively the last day of evidence and for the first time someone starts looking at the development plan.
Yes.
Okay, so we've got policy S1, haven't we?
Yes.
Okay, and as you identified in chief, it contains a version of, if I put it that way, the tilted balance, doesn't it, at the bottom?
It does, yes.
So what the development plan tells me through S1 is that if I have policies that are out of date at the time of making the decision, the relevant policies, obviously, you know, different now, it's the most important policy, you know, it changes a bit. So I appreciate this isn't exactly what is now in paragraph 11 of the framework.
Yes.
But what it says is the council will grant permission unless material considerations indicate otherwise, which is an odd thing to say, isn't it? Because that actually isn't the tilted balance. That's just.
But that is more in line with 38.6,
yeah.
isn't it?
But what that is actually saying is where I don't have relevant policies or my relevant policies are out of date, then I'll apply section 38.6.
I mean, I would accept if you read it in that manner.
Well,
yeah,
I do read it in that manner.
Yeah.
Do you read it differently?
Well, the way that I view it is that, I mean, it's not the best kind of, let's see, whenever you read it as a whole, I think the overarching intention is that we're applying 38.6 here.
Yeah, I mean, we'll get to that.
And that's the spirit of the policy in the inclusion of that, which is something that, that's my view on it, is that that's where we have to do with every application anyway.
Okay. Sorry, your words, spirit of the policy. And actually what we have to look at is the words of the policy, don't we? And we have to understand their natural and ordinary meaning in the context of the development of that plan policy and the other policies in the development plan. We have to use the words in the policy, don't we? We don't just read a policy and say, well, it says what it says, but I know what the spirit of the policy was, so that's what I'm going to apply.
That's a reasonable position, hold.
Yeah, okay. So what it then goes on to say is account will be taken if any adverse impacts of granting permission would significantly and demonstrably outweigh the benefits.
Yeah.
So it gets the tilted balance right, doesn't it? In the sense of significantly and demonstrably. Bit dubious to say account will be taken if any adverse impacts, because of course we know the point is you apply that test. Your starting point is I will grant planning permission unless the adverse impacts significantly and demonstrably outweigh the benefits. That's what the framework tells us, doesn't it?
Yeah, but that's the framework, and this is the policy.
Yeah. But even so, and then it also tells me I'm going to assess against the policies in the framework taken as a whole. So it's directed me to the framework.
Yes.
Yeah. So if I go off to the framework and I apply the tilted balance, or I take account of the tilted balance as required by this policy, and I reach a conclusion that the adverse impacts of granting planning permission would not significantly and demonstrably outweigh the benefits, then I can comply with the development plan, can't I?
Yes.
Yeah. I mean, it's a bit of a moot point because I've already been approved on the tilted balance in the framework, but as a matter of fact, the two operating in parallel, passing the tilted balance brings me in compliance with the development plan, doesn't it?
I think that's a reasonable position to hold.
Yeah. So this development plan, by incorporating this in policy S1, it has its own mechanism, doesn't it, to deal with the out-of-dateness of policies, or where it doesn't have relevant policies.
Yeah, and I think that it can be read. It's not obviously verbatim, but it's largely. Yeah, I think we both agree that it's very much in line with the NPPF.
For the purposes of the decision here, there isn't some shade of difference between the current version of the tilted balance and the sense that we're arguing about some footnote policy or anything like that, are we?
No, my view is that no.
Okay.
Sorry, your question was, I think, so if we pass the tilted balance, we would therefore comply with the development plan as a whole, and your answer was yes.
Well, I think.
Sorry, is that right?
I think, in fairness, the answer is you could do, because you might.
Yeah, it's a reasonable position to hold, but again, just because you pass the tilted balance, I think that and please correct me if I'm wrong.
You might be heavily in conflict with some of the
you can still be
but still pass the tilted balance. So you might say
you would be compliant with policy S1. I hope that's what the question was. That's my understanding of the question.
So yes, you could comply
with policy S1.
With policy S1, but still fail to comply with other policies.
Yeah,
as you suggested, and therefore not be in compliance with the DP as a whole.
Yes. So again, it's you. Yeah, exactly.
Okay. So sorry. Fine. Yeah.
So S2 then, no issue between us at all about the sustainability of this site. Principle of location, other than the fact that it's in the countryside as defined. Southminster as a location for development, the scale of the development in terms of Southminster and the spatial hierarchy. No issues at all between us. No. In terms of accessibility, no issue between us, is there?
No.
200 metres on foot to the high street and to bus stops.
No issue there.
Yeah. Okay then. And indeed, as such, the proposal is supportive of strategic growth, i.e. policy S2, isn't it? Because it's placing strategic growth in a location which is spatially acceptable.
I don't know if we can 100% confirm it's spatially acceptable because of the impact it could have on the landscape, except because that forms part of the spatial strategy as well. But in terms of its location to services and it is in my view, a sustainable location.
Mm-hmm. Okay, and then policy S8. Which is at page 45, also PDF 45. So although we've looked at the spatial policy in S2, S8 actually sets out the hierarchy.
Yes.
And we can see we are a larger village, second highest in the hierarchy. And then we get this text, don't we? The countryside will be protected for its landscape, natural resources and ecological value, as well as its intrinsic character and beauty. And you have provided your views in terms of countryside protection.
Yes, I think that the way that I read that is that it's in line with the with MPPF paragraph 187B.
Okay, so if we go to the framework. And section 15, page 54, para 187. So that tells us that planning policies and decisions, we're obviously decision taking here,
Yes.
but we're also looking at policy, should contribute to and enhance the natural and local environment by, and then it sets out a series of things that we will do to achieve that overall objective, doesn't it?
Yes.
Yeah. So we then look to those individual things, don't we, to see if they are relevant to our proposal.
Yes.
So, for example, C is not relevant because I'm not on the undeveloped coast.
No.
I'm not
Agreed.
concerned with maintaining its character.
Granted. Yes.
But we can look at these criteria and we can look at the words used, because the words tell us, don't they, how we are to treat a certain thing. If I'm dealing with the character of the undeveloped coast, then I need to maintain it, and I also need to improve public access to it where appropriate.
Yes.
Yeah. So if it were appropriate to improve public access, but my proposal is going to prevent that, or simply doesn't do it, and or I don't maintain the character of the undeveloped coast, then I'm not achieving that objective set out in 187C, am I?
I think that's a reasonable position to hold.
Yeah. And likewise, if I am a valued landscape in terms of 187A, and my scheme does not protect and enhance this valued landscape, then I would not be meeting that criteria, would I?
No.
No. We're in B, aren't we?
Yes.
Yeah? What I'm required to do is to recognise the intrinsic character and beauty of the countryside.
Yes.
Yeah? So recognition is different to protection, isn't it?
Yes, but whenever you read it as a whole with you should contribute and enhance the recognition of it, whenever you take the part 187, the sentence of 187.
But no, I do these individual things to reach that overall objective. We've agreed that, haven't we? My overall objective is to contribute and enhance, and then I look to these different criteria.
Oh, yeah, yes.
Yeah? And A is protect, isn't it? I protect something. B, where we are here, dealing with ordinary countryside rather than a valued landscape, I don't reach that bar of protection, do I? If the MPPF required me to protect the intrinsic character and beauty of the countryside, generally, the MPPF isn't afraid of using the word protect, is it? At B, it would say protect the intrinsic character and beauty of the countryside. It wouldn't say recognise the intrinsic character and beauty of the countryside.
Yes.
Yeah? So to that degree, the policy is inconsistent with the framework, isn't it? Because it sets a higher bar of protection. It applies the protection of 187A, i.e. valued landscape, to all countryside, because it requires its protection rather than simply requiring that one recognises it and factors it into your planning decision.
The terms used, the countryside will be protected for its landscape are within the policy, yes.
Yeah. So we're agreed then, there is an inconsistency there, isn't there?
Yes, my view is in practically it's relatively minor, but yes, there is a difference.
Well, I'm interested in your views, but in your proof you tell me they're consistent. But we've agreed, actually they're inconsistent, aren't they?
In terms of the use of that specific word of recognise versus protect, I suppose we can agree that.
And
yes.
this is an important part of this policy that you rely on, isn't it?
Yes.
Because, for example, looking at all these general criteria, we're not concerned with, for example, K, utility and highway infrastructure, are we? Or I, travellers and travelling show people accommodation, or F, rural diversification. Your point about conflict with this policy is that we do not comply with it because we do not protect the intrinsic character and beauty of the countryside.
Yes.
And that is a higher bar than the MPPF requires, as we've just agreed.
Yes, I think, again, I think that the MPPF, just going back to it, so apologies, give me. I think that whenever we read it in terms of the planning policies should contribute and enhance the natural landscape, I think that that is how the council have taken it, that the policies should contribute to the enhanced and natural landscape by recognising its intrinsic beauty as carried out an exercise of the intrinsic beauty, and therefore has determined that it should protect it by the instruction in the original sentence. That's how I read it.
Okay, so just what do you say the inspector should do? Should the inspector protect the site, or should he recognise it as countryside?
I think that is for his planning judgment.
What would you do?
Well, I've said that I viewed it as protect.
Okay. So just to be clear in closing, I'm going to say that's wrong. As we agreed, there's a difference between protection and recognition. The policy is inconsistent with the framework. Okay? So if the policy is inconsistent with the framework, that affects the weight that I'm going to give to the policy, doesn't it?
Yeah, if you yes.
Yeah. And then following on from that, if I conflict with the policy, and it is a policy that's inconsistent with the framework, that is capable of affecting the weight that I'm going to give to the conflict.
Yes, yeah.
That I then ultimately weigh in the planning balance.
Yes.
Yeah? Okay. In the statement of common ground, we didn't set out, to my recollection, the different scales of weighting. Mr. Tate sets it out in his proof. But from your proof, I understand that you have, or am I correct in understanding that you would have substantial at the top, because your point is I might have given X substantial, but because it's just, because of Y, I reduce it to significant. So I'm assuming the top of your scale is substantial.
The top of my scale is substantial, yes.
Yeah. Okay. All right then. You've got two, you've got, I think, one matter. Let me just double check. Sorry, I've got too many windows open. I've lost your proof, which I'd put in
always away with these things.
I'd put in its own special Adobe pane, and then couldn't find it. Okay, so looking at your table, we've got planning harms, and the one that we've got, which is of significant weight, is landscape and visual harm.
Yes.
Yeah. So you say it isn't.
Sorry, table. What?
Sorry,
So
the
6.1.
page 26 in Mr. Garrett's proof, and we've got table there of the planning harms and the benefits. So we've got landscape and visual harm, and you give that weight significant, which is one below the top of your scale.
Yes.
Yeah. And your reasoning, I know this is a summary, not holding you to exactly what's in the table because you explain further in your proof, but you rely on the evidence of Mr. Friend, who we heard from on the first day.
Yes.
Yeah. And you also say that the harm is directly comparable to that found in the dismissed Homefield appeal. Yeah.
Yes.
Where conflict with policies S1 and D1 attracted very substantial weight, and you afford the landscape and visual harm significant weight. Yeah?
Yes.
Okay. So, do you have a copy of Appendix B,
I think
landscape and visual effects?
It's in the core documents, and if you have it, could I get the reference? I don't have it to hand.
Okay.
It was in the landscape statement of common ground, wasn't it?
It was.
Hold on. I think I've got it in the table. Just waiting for it to download. No, wrong appendices. Because was it it was Appendix 1 of the statement of common ground, I think.
Appendix B. Well, actually, but that might be the appendix to the LDA. Yes.
Yeah, it says Appendix B on top of it, but yeah, no.
Okay. Yes.
Yeah, yeah.
Yes. I have that table. Yes. Yeah.
Okay. This, I know I don't want to do a disservice to the professional discipline of landscape assessment, but this distills, for the purposes of the planning balance, the position of the parties.
For our simple planners, yes.
Yeah, absolutely. Okay. So, in terms of landscape effects, well, let's start at, in the right-hand side, we've got construction phase, effect on completion, effect at 15 years. Yeah, the three time periods within which we assess the landscape and visual effects.
Yes.
We're agreed that they are appropriate.
Yes.
Reasonable to assume that the lifetime of this project is 100 years.
If
Possibly
if
more.
so,
Lots of houses are more than 100 years, but if I was going to look at the lifetime of this development, it's well in excess of 15 years.
yes, but I mean, for landscape purposes, we assess them for 15.
Yeah, it's going to be here for a long time. This isn't a project where there are construction stage effects, but this isn't some enormous infrastructure scheme lasting 10 years that is causing visual blight across a huge tract of countryside, HS2, a nuclear power station, or whatever it might well be.
No, it's not. It's not of the scale. Those scales, no.
Do you agree that the important one of these columns, really, given that how long the development will be there, is year 15?
Well, I mean, whenever I think they all have importance in the assessment.
Yeah.
And I think that whenever we, so that's my view. My opinion would be that for the long term, whenever we look into the long term impacts, obviously the year 15 is the starting point of that, but all have importance in that assessment.
Yeah. Okay. So just to frame where we are in terms of the harms, some of which are agreed, some of which there's dispute between the parties. But in landscape terms, the parties agree that in terms of the South Essex farmland landscape character area, i.e. at a county level, negligible.
Yeah.
Effects.
Oh yeah, sorry. Yes, yeah, that's agreed.
Yeah. And unsurprisingly, the same for national character area, also negligible.
Yeah.
Because in landscape effects, we sort of zoom in, don't we? We start at a high level and we work our way down with a more granular assessment, looking at the site closer and closer and closer.
Yes.
Yeah? And examine the effects. So in terms of the Malden landscape character assessment, we've got a year 15 position agreed of minor, adverse, negligible. Yeah.
Malden. Oh yeah, the Tillingham and Latchingham coastal farmland LCA. That one. Yeah.
Yeah.
Yes, agreed.
And then over the page, where we do have a disagreement, we're dealing with, the level of zoom that we're dealing with is the site and the immediate context.
Correct.
Yeah. So it's only in that zoomed in element that we've got anything more than minor / negligible, isn't it?
Yes.
Effects. Yeah. And the difference between us, even on the, just the site itself, which unsurprisingly, there are adverse effects in landscape terms, because a landscape assessment takes as a good thing undeveloped land, doesn't it? When you build on land, that is a adverse thing in terms of landscape assessment.
Generally, yes.
Yeah. I'm not aware of any development involving infrastructure and built form where you've gone from a greenfield site and that there's positive landscape effects.
Okay.
Yeah. And what we are here, in all the scale, is we're at moderate, or not we, Mr. Holiday is at moderate minor adverse. Mr. Friend is at moderate adverse. There is, in terms of scales and ratings, there is not a great deal between, is there?
Well, it's up to the next level, yes.
Yeah, half. Well, it's sort of, yeah. We're at moderate minor, and that's at moderate. It's half a rating.
It's higher, yes.
Yeah, and then we move on to visual effects, because of course in our assessment we look at landscape effects, don't we? And we look at visual effects. Two different things.
Yes.
And there's no debate that the viewpoints that have been assessed, the receptors, they are all agreed as fully encompassing and representing the visual effects of the proposal.
No, there's no disagreement.
Yeah, I haven't got anybody else saying, oh, well, this viewpoint.
No, we agree that, yes.
And in terms of that, we've got 3 pages worth. I won't add them up, but there's a reasonable number there, isn't there? And it's on 2 of them that we disagree.
One, 2.
Yeah, P1 and P2.
Yeah, yes.
Okay. And in terms of disagreement, there's disagreement for P1 at year 15 is one of moderate minor adverse. So says Mr. Holiday. Moderate adverse says Mr. Friend, yeah?
Yes.
And then we've got P2. Mr. Holiday says minor adverse, and Mr. Friend says moderate adverse, yeah?
Yes.
Okay. So just looking through these overall effects, let's do it. Let's start from the beginning. Start with landscape characters. Well, we've already done this one. First page is negligible, negligible, minor, adverse, negligible.
Yeah.
Second page is moderate, minor, adverse versus moderate, adverse.
Yep.
Move on to visual effect, and we've got minor adverse, moderate adverse, minor adverse, minor adverse, negligible. Then we've got a dispute of moderate minor versus moderate, and minor versus moderate. Yeah. And then over the page, negligible, minor adverse, negligible, negligible, minor adverse, negligible, minor adverse, negligible, and minor adverse, negligible.
So just could you just kind of specify which, just the reference of P1 or R3 whenever you're running through that, just lots of negligibles and moderates.
No, that's fine. Okay, so and perhaps because you've got it on the screen, maybe you haven't got the pages. So let's go back to the beginning. Landscape effects.
Yeah.
National landscape character, negligible. Landscape character area, county, district, both of them. First one negligible, second one minor, adverse, negligible.
Yes.
Immediate site we've looked at. We've got a moderate, minor versus moderate.
Mm-hmm.
Then we move on to visual effects. R1 agreed as minor, adverse.
Yes.
R2 agreed as moderate, adverse.
For the 15 years, yeah.
Yeah, R3 agreed at minor, adverse.
The 15 years.
Yeah, R4 agreed at minor, adverse, negligible.
Yes, 15 years.
P1 we've looked at, difference of opinion is moderate to minor adverse versus moderate.
Yes, again, that's there's the other difference at the overall effect upon completion in winter, that there's a difference there as well. And we then also have differences in the size, whenever we judge magnitude of the visual effects as well. There's differences there at completion and at year 15 as well.
Okay, and then P2, looking at year 15, we've got minor adverse versus moderate adverse.
Yes, and again, there's differences within the overall effect at construction phase and the overall effect at completion of winter as well. There's differences there. And then we also have differences within the size, scale, and visual effect at the stages of the project, where at P2, construction is medium for Mr. Holiday. Right, that's his name, isn't it, Mr. Holiday? Yeah. We have construction high, medium, whereas Mr. Holiday has medium. Then completion high, medium, where Mr. Holiday has medium, and then year 15 low, medium, where Mr. Friend has gone medium.
Yeah, but ultimately that's the magnitude of the effect, isn't it? Which combined with the sensitivity gives us our overall effect on the right hand side. So that's interesting working. But what we're actually concerned about is the conclusion of that working. Yeah, that's how the LVA assessment works, doesn't it?
Yes, largely, yeah.
Yeah. Okay. So, the most valuable thing to take from this to feed into our planning balance is the individual conclusions, isn't it? Not necessarily the building blocks, because the building blocks, the magnitude, the sensitivity, takes us to our overall conclusion, doesn't it? They are combined to give this judgment.
Yeah, I think that's a reasonable position.
Yeah. Okay. So P3, we're agreed at negligible.
Yeah, we're everything from P3, H1, H2, H3,
We're agreed.
H4.
So we're minor reverse, negligible, negligible, minor reverse.
Agreed.
Yep. Okay.
Yeah.
Thank you. I don't see the word significant once in any of these conclusions, do I? From either the council's landscape witness or from Mr. Holiday.
No.
So
you wouldn't, because that's not the scale used.
I don't see major, do I?
Well, we have there's a few major moderates, but exclusively major now.
Yeah. Well, in year 15, I don't see any major moderates, do I? I don't see the word major.
Yeah, we just need just to be with year 15. Yes, we don't see that, but we do see the word major, but we wouldn't see the word significant either. So just sorry to be.
No, you're quite right.
I just want to be accurate.
And the inspector needs to get it right. But at year 15, we don't see anything above moderate, do we?
No.
Okay, let's have a look at CD 9.5.
Can I put that table away now? Or are we
Maybe
still
just keep it to hand just for.
Yeah, okay.
9.5.
Yeah, so this is the appeal decision. This is the Taylor Wimpey appeal decision, which you have told us you have considered.
Yes.
CD 9.5, yeah.
Yeah. Yes, sir.
So the Homefield West is Tillingham Road one. Yes,
that's right. Okay. So we know, obviously, that this scheme was refused.
And dismissed it.
And we know from paragraph 99 that the inspector concluded that the appeal proposal would result in substantial adverse impacts to the character of the host landscape and harmful visual effects from various perspectives, which would very substantially harm the character and appearance of the area.
Yes.
Yeah. Okay. And then, unsurprisingly, we see discussion, or more detailed discussion about the landscape and visual effects, which start on page 2 with the heading Character and Appearance from paragraph 12 onwards.
Yes.
Yeah. Okay, and there is description of the land. The inspector's seen the site, so I'm not going to go through and point out what differences there might be. The inspector knows where our site is in comparison to the site. That's all self-evident from his visit.
Yes.
Paragraph 20, we start to get in the assessments. Now, the inspector refers here to the council's assessment. Of course, the witness for the council in this appeal was Mr. Drummond, wasn't it?
Yes.
Yes. Mr. Drummond was the consultee on this appeal, wasn't he?
Yes.
Yeah. Mr. Drummond, having participated in the appeal opposing that scheme at Homefield, and having considered the appellant site where it is, can be taken to have pretty extensive knowledge of this locality, can't it?
I suppose so, yes.
Yeah. Mr. Drummond's advice to the planning officer and subsequently to members was that the scheme could be accommodated satisfactorily on the site in landscape terms, wasn't it? He raised no objection to the scheme proceeding.
That's my understanding, yes.
Yeah. So this is an example, isn't it, where, as you say, members exercised their judgment differently to the advice that they were being given not only by their officers but also by external consultees, and then set about, for the purposes of this appeal, finding somebody else who could support their views. Yes?
Well, yeah, I mean, Mr. Drummond wasn't considered to defend it.
Okay. So paragraph 20, the last sentence there, the start of it is some description about it. And then the inspector says, accordingly, I share the council's assessment that the appeal site has a high sensitivity to change. Yes?
Yeah, that's what it says, yes.
Yeah. It is agreed, isn't it, in terms of the appeal site, that it does not have a high sensitivity to change. If we go back to the landscape, if we go back to our Appendix B.
Yeah, sorry, I'm going to have to load it up again, so. Oh, yeah, if you've got a paper copy, that'd be really great. Thanks. Thank you.
Okay, so in our table, we've got a column toward the left-hand side that's then subdivided into three. It's judged sensitivity of landscape.
Yes.
You see that? And then we've got susceptibility, landscape value, and overall sensitivity.
Yes.
Yeah, they are the building blocks that go into our overall conclusions.
Yes.
Yeah. The conclusions as to those building blocks influence the overall conclusion, don't they?
Yes.
Yeah. In terms of the Homefield site, the council's assessment there, with which the inspector agreed, was that there was a high sensitivity to change in terms of that site.
That's what it says in the appeal.
Yes, that's different to the case here, isn't it?
I mean, based off what I'm not familiar with.
Based on what the two experts have agreed for the purposes of this appeal, as recorded in here.
Yeah.
That is different, isn't it?
Yes. Yeah.
The inspector also recorded that she shared the council's assessment that the resultant effect of the development on the character of the landscape would be substantial and adverse. Yeah?
Yes, that's what the sentence says, yeah.
And again, looking at our tables that we've been through, we don't see, and I appreciate, that the words are not necessarily the same. The top would be major rather than significant or substantial in landscape terms versus planning terms. But where we're looking at columns of negligible, minor, and a few moderates, we are not entering the territory of substantial harm, are we?
No, and that's why we set out significant harm.
Yeah, but that's a difference again, isn't it, between this appeal and that appeal decision?
Yes, which
this site and that appeal.
Yeah, which is what we've set out in the landscape evidence that we accept. Hence why Mr. Friend he's gone through and accepted these things, and highlighted that there's only a difference in professional judgment on those sites. We've agreed that in Statement Common Ground for landscape.
Yeah, but I just want to go back to, can we just go back to your proof and the planning harms? Yeah? We started, didn't we, in this table, landscape and visual harm. Yeah? And what you say there in your reasoning, the second paragraph, is the harm is directly comparable to that found in the dismissed Homefield appeal. That's not right, is it? It's not directly comparable, is it?
I regret using the word directly, but it's comparable. Yeah, but it is comparable in terms of its proximity to some of the same viewpoints. It's comparable in the fact that it is also on the edge of the settlement of Southminster, and some of the same viewpoints were assessed as within that as well.
Okay, so it's comparable because it's in the same neck of the woods.
Largely, yes.
Yeah.
But again, there is still that urbanising effect that which we accept, it does have an adverse impact on the countryside.
Yeah. Okay. Well, let's look at those. Let's carry on. Let's go back to that appeal decision, paragraph 21.
Yes.
We know from the conclusion here that the inspector referred to visual effects, adverse visual effects, a number of different types of adverse visual effects affecting different receptors. That was the conclusion we looked at. And in the reasoning, we get those drawn out, don't we? So paragraph 21 is dealing with the several properties on the home field facing the appeal site. Yeah?
Yes.
Okay. So in terms of visual amenity, the inspector found that the effect of the development on those properties would be substantially adverse and be unlikely to be moderated to any noticeable extent. Yeah?
Yes.
Yeah. There are no properties, are there, that have been identified in any of the assessments which would have substantially adverse impacts on their views in the present case?
No, we haven't identified any in that regard.
Yeah. So that part of this appeal decision isn't directly comparable to this appeal, is it?
No.
No. Okay. Paragraph 24. We're dealing here, the inspector is dealing with the approach to the village from the north along Tillingham Road. Yeah?
Yes.
Okay. Now, obviously we know, in fact we discussed it on the first day when we looked at the development framework, when we looked at Mr. Holliday's appendix drawing, which put the two schemes together on an A3, and taking the plan for the home field scheme, there was a red arrow, which was the vehicular access from
along Tillingham Road.
From Tillingham Road, yeah. So that again is a point of distinction between this scheme and that scheme, because that scheme, the access was out of the settlement on Tillingham Road, wasn't it? Whereas here, it is part of a suburban road.
Yes. The appeal scheme does connect on the Queen Road. Yes.
Yeah. And what the inspector said at paragraph 24 is, when I approach the village from the north along Tillingham Road, or when anybody does, so I'm heading south, the rural character and extent of the appeal site is prominent within the field of vision, because of course as you come down Tillingham Road, and again the inspector I think was going to go and look at this again, the site's right there, isn't it? As you're going through those bends and there's gaps in the hedgerow, and that is the site.
Yes.
The home field site.
Yes.
Yeah. And then you get to the access as well. Yeah. So what the inspector said, that the openness on the approach to Southminster along Tillingham Road is particularly appreciated because the bend in the road provides an opportunity to experience views over the site. Yeah?
Yes.
Yeah. So that was applicable to that site, that appeal site. Not applicable here, is it?
No.
No. Okay. And what the inspector said is that because of those views over that site, the loss of agricultural landscape would be keenly and harmfully experienced by road users, where development in the foreground would noticeably erode the rural context of the village, foreshorten views, and contrast harmfully with the immediate open agricultural surroundings. Yeah?
Yeah, that's what it says.
That is not a harmful effect that arises from this scheme, is it?
No, because the access is through Queenborough Road.
Yeah, and we're not located next to Tillingham Road.
No, but then no other site could have that effect if you apply that.
But
I'm just saying that you're saying if we can't hug in any other side effect to Tillingham Road if you don't go down Tillingham Road.
I'm exploring how directly comparable this appeal
I understand that, yeah, I get that.
Talking about landscape effects and visual effects here. We're not talking about noise. Yeah.
Okay, so then 25, the inspector makes reference to the required highway junction, i.e. the access into that site, and says that would introduced notable urbanising features along the lane, that lane being rural in character. I think we've already covered this point. We're different, aren't we?
Yeah, yeah.
Suburban in character, etc. So that's different?
That is different, yes.
Yeah, okay. 28, the appeal proposal would conspicuously diminish rural views from the lane. This is Sheepcoats Lane. Yeah, the bridle way. 27 tells us that we're dealing with Sheepcoats Lane.
Sorry, yes.
Yeah, and then we go to 28. So from Sheepcoats Lane, because of course that Homefield scheme was up to Sheepcoats Lane, wasn't it? We looked at the framework plan, and there was a little connection point into Sheepcoats Lane, and the development parcel was up to Sheepcoats Lane.
Yes, agreed.
Yeah, that's another point of distinction between that scheme and the appeal scheme, isn't it?
Yes.
Yeah, and what the inspector said there was that in terms of that, the effects would be substantially adverse. Yeah.
Yes, agreed.
Yeah, and that even if there was some planting, the effects on the lane's rural qualities would still be significantly adverse.
Yeah, that's what it says, yes.
And again, we've been through our table. We're not anywhere near that level of effect, are we, in terms of our scheme?
No, we aren't at significant, major adverse.
No.
Well, there's somewhere moderate major, but we aren't at major adverse, rather than.
Okay, and then 32. Drawing matters together, the inspector in that appeal scheme says, third line, in the identified adverse impacts to the character of the host landscape and the harmful visual effects from various perspectives. So that's drawing everything together, isn't it? It's drawing landscape effects together and all the different visual effects. Yeah, this is a concluding piece.
Yeah, just reading through it. Yep, that's what it does.
Okay, and we've got very substantial. It would very substantially harm the character and appearance.
Yes.
Of the area. Yeah, and again, when we look at this, we're not anywhere near that, are we? Because our agreed assessments aren't anything like that level, are they?
No.
No. So, other than that appeal scheme happening to be to the north of Southminster, it isn't directly comparable, is it?
It's comparable in the fact that it does have those urbanising effects on the countryside.
Yeah.
And
but that is inevitable from a greenfield site. The important point for the inspector is, what are the levels of effect from urbanised, building on a green field, aren't they? Not just the fact that there is building on a green field.
Yeah, and the effect that those have, yeah.
It's fair to say, isn't it, that what you were inviting the inspector to do by saying this is directly comparable is saying, well, look, it was substantially adverse over there. It was really bad and it was refused. It's directly comparable to this.
Well, what I was highlighting that
directly comparable.
And as I've said, I do regret in terms of my drafting using the word directly.
Yeah.
In hindsight, I do regret that. I think that there are elements of it that not every single element. Of course, we've gone through that exercise now. Is comparable. It obviously is its own side. It has its own effects. But I still, I am of the view that those changes in terms of the moderate adverse effects that our evidence supplies does mean that coming to a significant planning position is that's my view.
Okay, and that is your view, but we can agree, can't we, that it's wrong in that table to say directly comparable.
Yes, and I accept that.
The inspector should effectively strike through that directly comparable point.
I think
your evidence isn't inspector. Look at Homefield; it's directly comparable to the appeal scheme.
I would say it's comparable rather than directly comparable.
How is it comparable? Given what we've just been through, how is it comparable? Other than the fact that it is a residential scheme to the north of Southminster.
Because just to just refreshing my memory on my proof, so please forgive me. Because whenever we look at the kind of the
Take me to the bit you're looking at.
Yeah, I'm just running through it just generally.
Okay, just generally. Okay.
Yeah. Just. So then, if we look at what I kind of set out from 4.12, 4.12 down, we have that the proposal would have that moderate adverse landscape effect, construction residual phase differing in the impact that was set out in the planning submission. We agreed that there is a difference there, and simply because it would result in those different moderate adverse effects. My view is that that it would therefore tip over, and I appreciate this is a finely balanced point, and obviously there is disagreement between myself and Mr. Tate on that point. But given that case, we then have to assess it against policy D1, which is still in, which we aren't disagreeing is out of date, which helps with the landscape. And whenever I look at it from a planning sense, that's where the significant, that's where there is an element of comparison. I agree that directly comparable is incorrect in a number of circumstances, but whenever we look at it from a planning sense, which is what my table is looking at, rather than the landscape sense, that is for Mr. Friend and Mr. Holiday, they've already gone through the round table. In a planning sense, I still think that there is the significant weight should be given to the fact that it's contrary to D1, which is set out in 4.14.
Right. I mean, it's not. I don't think it's going to come as any surprise to you that I'm going to be putting in closing submissions that when you've got an agreed position between the landscape experts, none of which exceeds a level of moderate harm, then it's very difficult to comprehend how anybody in the planning balance can take moderate harm and say that that's significant. That should be, that is a harm of significant weight. So, just putting it out there.
No, that's fine.
But that is what is going to be said. That said, significant is the second highest level of your scale, isn't it?
It is.
Yeah. So, I appreciate there are a number of judgments in here. We've got several pages worth.
Yes.
That, for planning purposes, need to be blended into a single weighting.
Yes.
Yeah. In this particular case, we say it's quite straightforward because the most we've got, the very highest level of effects that we've got at year 15, which we say is, bluntly the most important assessment given the lifetime of this development, is that we've got some moderate adverse, albeit they are in the minority. Yeah. And in terms of visual effects.
Yeah, they're still there.
Yeah, they're still there. Yeah.
I accept they're in the minority.
So let's imagine a world where instead of I've got some minors here, I've got some moderates. I've got one major or two majors. Where is that in your scale?
Well, they're two different scales.
No. I'm taking this. Yeah, you've taken this.
Yes.
And you've come up with what weight you're giving to the landscape harm, and you say there's significant weight to be given to the landscape harm. Yeah.
Yeah, in planning terms, yes.
Yeah. So if my assessment, if these assessments were different, if they were slightly higher, I've got, instead of two moderate adverses on viewpoints, I've got two majors adverse. If that was the agreed position, where are you in planning terms? Are you still significant, or are you now up to substantial?
Well, in terms of the hypothetical, I think that it's difficult to say exactly, but again, this is finely balanced. I'd probably stay in significant. But I'm not. I wouldn't go up to substantial. But again, it's completely contextual. And I've taken the evidence that Mr. Friend has given the council and taken on board. I accept that is a finely balanced matter. But my view is that it is crept into the significant harm.
Yeah. Well, I mean, you say it's finely balanced. You know, be under no misunderstanding, and just want clear to the inspector, we don't say it's finely balanced. It's clear as day from the assessments that you don't get to significant. But there we are. All right. So in terms of harms to the living conditions of the occupiers of number 48 Queenborough Road.
Yes.
This ties into a degree, just the first part of this discussion, about the attenuation barrier. You were talking in chief about a conversation that the case officer had with the environmental health officer that then was reported to you about maybe there wasn't a height, but some height might be necessary. We don't see any of that in any of the evidence that's been provided to the inquiry, do we? The first time we've heard about any of that has been in your examination in chief.
Yes.
Yeah. And that is presumably you reporting a conversation that somebody else had with somebody else.
But that I have with the case officer whenever we, yes.
Yeah. Okay. Now, yesterday, obviously, we had a lot of discussion about sound. In your chief, you were talking about, well, it wasn't clear that a 1.8 metre high fence would be able to, or a 1.8 metre high fence wouldn't be able to ameliorate the alleged impacts, level of impacts on the first floor rear elevation. Yeah?
Agreed, yes.
Yeah. But that isn't what the barrier is doing. The barrier is dealing with the garden noise, isn't it?
Well, it's dealing with the amenity impacts that the proposals would have.
Yeah. But in terms of all the assessments that were done, they were done on the basis of a 1.8 metre high fence. That was agreed yesterday.
Yeah, because that's what's kind of found on site at Mr. Agarwal's property, yes.
Yeah. And we haven't turned up and said, oh, well, we agree with you, council. There is a problem on the rear elevation. Our solution is a 2.5 metre high fence.
No, you haven't suggested that, no.
Because our position is, well, there isn't a harm.
Yeah, that's where we're in dispute.
Yeah. And therefore, in terms of this point about harm to the street scene, we've heard that the acoustic fence has been assessed on the basis of being 1.8 metres high. Yeah?
Yes.
We've heard Mr. Bryan agree that it need not come to the back of footpath on Queenborough Road.
Yes.
Yeah. There is already a 1.8 metre high fence along that boundary.
Yes.
Yeah. If a 1.8 metre high fence went along that boundary, there would be no change, would there?
Along the boundary of to Queenborough Road, is that?
Along the boundary of number 48.
So I just want to be clear. So we're saying if there was
North-south.
But because if we have a 1.8 metre high fence all the way to the Queenborough Road boundary, is that what you're asking?
No.
No, just so if
No,
we have a fence.
Mr. Bryan agreed yesterday that if an acoustic fence is required in that location.
I just want to be absolutely clear on what you're asking me. That's all.
Right. At the minute, there is a timber fence that's 1.8 metres high that actually does go all the way to Queenborough Road.
Yes.
That separates number 46 and number 48.
Yes.
Yeah. Mr. Bryan agreed that for acoustic purposes, the fence need not extend all the way to the back of footpath at Queenborough Road. Yeah. If number 46 were demolished, and if the access road were to go per the worst case scenario, if I put it that way, along the as shown in the original plans.
Okay. Yeah.
Yeah. Then a 1.8 metre high fence would be placed along the line of an existing 1.8 metre high fence, wouldn't it?
Well, yes.
Yeah. There would be no difference, would there?
And if it turns out to be a 1.8 metre high fence, then I agree that there would be no harm.
Yeah. Okay.
But
now, in terms of anything else that might be required, if nobody's proposing a 2.5 metre high fence, we as the appellant are proposing it. But if we did, at Reserve Matters, come along and say, you know what, I quite fancy putting up a 2.5 metre high fence, and if the council considered that to be unacceptable, then the council would refuse the Reserve Matters. But that isn't what we're dealing with, is it?
Well,
the proposition is a 1.8 metre high fence.
No, well, I think that's the point is, what is the fence there for? I think we have to go back to that in terms of the first principle. is to minimise the impact on amenity. Correct? That's why that's why.
No, it's part of the proposal that has been put forward is a 1.8 metre high acoustic fence. I appreciate there appears to have been some confusion at the council whereby the proposal for 1.8 metre high ends up being reported in the officer's report as a fence of 2 to 2.5 metres, which now you tell us in examination in chief was the result of some telephone conversation off, the top of people's heads. We have been scratching our heads wondering where that has come from, because it doesn't come from anywhere. It doesn't come from us. It doesn't come from any of the council's evidence, because the council didn't have any noise evidence until a few weeks ago. So you can understand why our view was. But our position is 1.8 metre high fence where there is a 1.8 metre high fence. So that there can't be any harm, can there?
Well, but what the point is that within the proposed condition, that was condition 36, we set out that approval should include an acoustic fence that will be located within the site and shall include the details of the performance to mitigate the noise arising from the development.
Yeah.
So we accept that. So that's it there. So if a 1.8 metre high fence was unable to mitigate the impact, then 1.8 isn't going to be big enough.
Right. So your position is effectively if we end up with something that is different to what you are proposing, then that would be harmful.
Well, if we are dealing with something that is in that kind of that much larger, then yeah, I think it would have.
Yeah,
again, granted, a limited.
That isn't what's on the table, is it? That's not what.
But at this current stage, there is dispute as to whether or not the fence is mitigating the harm that is being caused.
But the fact we don't say, and I didn't understand the council to be saying that the attempt of the fence was to mitigate the alleged harm to the first floor, because the first floor is higher, isn't it? The fence is dealing with the garden noise.
But the fence is dealing with
isn't
noise.
Our proposal. We haven't come forward and said, oh, even if the council is right and that there is some adverse effect on the windows, let's have a taller noise barrier. We haven't turned up and said that.
No, and I respect that, but your position is that there is no impact. So why would you turn up and say that?
Well, because we could have alternatives, couldn't we? We could say, well, Inspector, even if the council are right, let's have a taller fence. That isn't what we're saying. My point is that the idea of a taller fence has just come out of thin air, and you're attributing it some level of harm.
I'm attributing it. I just remind myself. I'm attributing it as limited harm.
Yeah, but let's not forget, you do consider the planning balance to be finely balanced.
Yeah. Okay,
so we are dealing in things that are limited, aren't we? They're important because even that could tip a fine balance, wouldn't it?
But I think this is fundamentally.
Do you agree? I mean that.
Oh yeah, no, 100%. I agree with that. Yeah. That's a fair position to hold, that this is finely balanced, and the weighting of each of the harms versus the benefits is important in the tilt of balance. I agree with that.
Yeah.
I think it is just a case of, if we take a step back, and we disagree with the appellant's noise evidence, that much is obvious. And I think that if we were to suggest that an acoustic fence is there and we have identified amenity harm, and one of the ways to deal with said amenity harm is to change the height, design, whatever it may be, of the acoustic fence, that is not an unreasonable position to hold. And again, it is for a reserved matter, so that is where the position is that we could.
Sorry, can I?
Of course, yeah.
Can I just ask you? I mean, in order for an acoustic fence to mitigate the noise going to the first floor, which is I think what you're talking about, it would have to be 4 meters high. 5 meters high.
Well, I think that what we have is, in this case, we have based on our noise evidence, we have something that crosses over if we take the LA Max position that Mr. Bryant held, we cross into that significant threshold that was set out in the PPG, which says that it should be avoided. Yes. But if we decide that, if we accept that we're in that area, then there shouldn't it should be avoided and it should be redesigned. And granted, they can of course do that through the reserve matters stage.
But is that what you mean? So if I was to allow the scheme, and then you had to decide at reserve matters how high, how big the fence should be, then the council would be seeking to put a fence high enough to mitigate the noise to the first floor. So it has to be 5 meters high or something like that. Yeah.
I can't say exactly how high it's going to be.
No,
because
no,
the model is going to,
but
but I think
that's what you mean, is it?
I think because again the weight is being attributed to the effect on the street scene rather than the noise. The noise is being handled by its own
Oh
set
yeah, I
area.
understand.
So I'm saying that if we are dealing with something where we don't know exactly what the height is, and granted, I know it's going to be, I suspect where I know where your next question is going to be, but if the fence is going to end up being 1.8 meters high, of course, I'm not going to suggest for 1 second that is a harmful position. And I also respect where we're coming from in terms of reserve matters and everything like that. I appreciate that those details are there. And I also appreciate that the noise position, we are in dispute. All I can do in terms of the noise is take what the council's evidence is, and therefore, until we have clarity as to how big that fence could be or would be, I have to presume that it's going to be to mitigate the impacts it could have, and if it's going to be higher than 1.8 or higher than kind of 2.5, which was suggested by the EHO, and I understand the frustration. I'm sympathetic towards it, but
you have to take that into account.
But I have to take that into account because that's what was reported to members as well. It's that's what the case officer did. That's what the members made the decision on, and there will be questions about that, no doubt. But my position is that if we are going into that 2.5 meters in conjunction with the kind of the demolition of 46 as well. I think you said if you were going to demolish 46, my understanding is that as part of the proposal, which in combination, if we have an acoustic fence that is significant in height, then that is going to have an effect, albeit I accept that it is a limited effect.
Okay. Sorry, go on, Mr. Hawley.
No, thank you, sir. So you get to limited effect if, rather than our proposed 1.8 metre high fence, there were to be a proposal for something significantly higher.
Well, so, yes.
And if it's at 1.8,
there would be no effect
to be weighed.
Yeah.
Right. Okay. Heritage harm. Obviously, I found it slightly torturous going through your proof, being told that the public benefits were and weren't outweighing. But we get to the end, see what you say, you tell us what the statutory framework, the statutory requirements are, great weight here, great weight there, the inspector's already commented on it. But essentially where you settle on is, in my planning balance, it's something of limited weight. Because that's what you say in the table.
Let me just get the table up. Yes.
Okay. And then lastly, on the harms, we've got loss of agricultural land, and your reasoning is that the loss of agricultural land is a harm recognised by the framework. Obviously, the BMV reason for refusal has been withdrawn because it's not BMV.
Yeah.
And then you say, I afford this residual harm neutral weight.
Yeah.
So whilst it's in your table, it doesn't.
Yeah, it does. It has an effect.
Equally, it could be out of the table because it's neutral.
Yeah,
it doesn't make any difference. It doesn't sit on either side of the balance, does it?
No.
All right.
It's not a harm.
No. But that's why. But again, it's.
All right. We've got a disagreement turning to benefits in terms of the weight that should be ascribed to them. You have referred to land west of the cemetery. Sounds like an attractive address, doesn't it?
Yeah, I know.
Can't wait to live at number 3 land west of the cemetery.
Well,
It might have a new name by then,
Yeah,
Martin.
but you live in Manchester, so
Yeah.
oh, that's a joke.
Yeah.
Here to hear what you have to say about Belfast.
Okay. So we've had a look at this, and this is a scheme for 275 residential units, and as we discussed earlier, Mr. Tate sets out in his proof what his scale is of weights.
Yes.
Yeah, and you've confirmed what yours is: substantial at the top, significant, moderate, and then wherever we go below that.
Yep.
Yeah. Okay. We don't have anything before us as to what the scales of weights the different witnesses in this case were advocating, nor indeed whether a single scale had been agreed as part of the statement of common ground.
It had been.
Okay.
So
where
it was in line with my one.
Okay. Where do we see that?
It's in the I think I'm pretty sure. Okay. Well, I will.
I mean, where do we see that in the inquiry documents?
In our inquiry documents.
Yeah.
Well,
we don't now just go off to the internet, don't we, to find some documents in the middle of cross-examination. If you're looking to rely on this appeal decision.
Well, to be fair, the appeal decision was submitted post-proof.
Yeah.
Which was decided post submission.
Okay. We don't have anything in front of us, do we? Saying what scales the parties were working to.
No.
No. Nowhere in this appeal decision does the word substantial appear, does it? Or very significant.
I'll take your word for it.
Yeah. So there isn't any discussion here. I mean, there's a whole thing on weighting. You know, we get to paragraph 83, and we've got a section here on weighting. Yeah. There's no discussion here, is there, with the inspector saying, well, the appellant says I should be giving substantial weight to housing or very significant weight to housing, but for the following reasons I disagree and I afford it significant weight. We don't have any of that, do we? We just have significant weight throughout the various weightings. We don't know, do we, whether significant weight was the top weight in this case, or whether there was something above it.
Well, I think we can.
In Homefield? Do you mean
in
west of
Cemetery?
Oh, in Western Cemetery.
Yeah.
Well, in answer to your question, no, but I don't know if they're. I'm not sure, but even if so, our inspector's duty bound to use the exact same weightings.
Sorry.
So we are using different weightings.
Yeah.
So in theory, Mr. Fagan doesn't have to use the weightings that we're using in our proofs.
But I presume you've gone to this to say, well, there was a lot of houses here, more than this appeal is proposing, and significant weight was given. That's what I understand the purpose of going here was. To support your view that significant, not substantial, weight should be given to the provision of housing.
Well, I think it's a material consideration, yes.
Yeah, but we don't know, in this case, whether significant was the top bar or not, do we?
Well, I mean, again, this is from my memory.
This inspector might have been giving it the very highest level on the scale that inspector uses, or that the parties had agreed. We don't know, do we?
Well, we as Bell Cornwell were instructed, and my colleague Martin Moss.
You there?
I've seen the documentation, and my understanding is that the weightings were similar to mine in my planning benefits. I would need to. I can't say I would need to verify that, but I think that it's considering that we have submitted it and it's been agreed to be submitted. I don't think it's necessary. I'm not suggesting the inspector go through every single document, but if this is a point of contention, I don't think it's unreasonable.
I mean, it's a document that you've put forward to support a proposition that you've made.
A decision.
It's not for me to invite you to go and find some more documents to make good the point, is it?
No, but
just exploring what benefit or what use the inspector can make of this.
Well, I think
we can agree, can't we, that on the information he's provided, the inspector doesn't know what the scale was.
Well, I think that what I can say is from memory, with my limited, but with albeit my limited involvement, but my involvement with that appeal, the scale was the same as what I put out under 5.1 in my benefits. I would need to verify that to be completely fair, but that is my understanding. And then furthermore, again, I'm not, and Mr. Fagan might be able to address that. He might use his own, they might use their own scale in assessing that, but my understanding is that the evidence 5.1 sets out the scale that was used and agreed in the statement of common ground with Savills for that appeal.
Yeah. I mean, you know, to put it all in context, we're dealing with shades of failure here, aren't we?
What do you mean?
In terms of the shortfall.
But shades of failure.
Shades of, the council is failing to do what it should do, which is provide the minimum level of housing.
There's no disagreement there.
Yeah. You say that the weight attributable to the delivery of new dwellings must be appraised in the context of the considerable improvement in housing delivery since March 2025, yeah?
Yes.
Yeah?
But
the council's still failing, isn't it?
Yes, but we also accept that an authority that is has 0.1 year 5-year housing land supply versus 4.99 would be different.
Yeah.
We're and granted some of those do come from appeals as well, but of course, and that is something to be considered. And
we've been looking at one, haven't we? That is an example.
Of
members in this authority that doesn't have a 5-year housing land supply refusing schemes that shouldn't have been refused.
But I mean, they have come to different planning decisions than an appeal.
Yeah. And in terms of improvement, it's correct to say, isn't it, that 5 out of the last 6 monitoring years, the council hasn't had a housing land supply?
Yes. Though that their position was impacted by obviously, and again, it's what happened in December 2024.
But that was less than 2 years ago, wasn't it?
No,
we're talking about 6 monitoring years.
Yeah, no.
I know a lot of authorities turn up and say it was great guns and we were doing a fabulous job up until our housing requirement doubled, but now we're doing our best. This is an authority that was, you know, that came 4 years into the monitoring period we're talking about, where the council was failing to provide enough housing. Yeah.
I agreed that there is historic issues. Yes.
Okay.
Sorry, in the Cemetery Road decision, does it not mention the scale? Weighting.
I don't.
Can't remember.
In the appeal decision itself, I don't think so. But I would need to just double check if the scale was qualified in that. But
it doesn't say.
No.
Okay. I mean, I'm going to read it all anyway. So yeah, fine. Okay, fine. Sorry, go on, Mr. Horn.
Thank you, sir. In terms of that suggestion of considerable improvement, I mean, you've already accepted the point that, you know, a proportion of that is appeal decisions, i.e. schemes that should have been approved in the first place and potentially now delivering earlier than they otherwise, potentially delivering earlier than they now will. Mr. Pycroft also makes the point in his proof. What's the reference? So CD 13.5.
We have to look all that up.
No, I can just give you the reference. I know that you're keen to leave Mr. Pycroft's evidence in its box because we are agreed. But it's just a short point about the future position.
No beef against Mr. Pycroft.
Do you have that?
Yeah.
Okay, so what he's done is he's provided an assessment, a future position as at the 1st of April 2026, i.e. the next monitoring period, yes?
So I missed where we
Where in
512, page
512.
27, sorry, I didn't say.
PDF 27?
PDF 27, yeah. Internal page 24.
Yes.
Yeah, and we see some analysis provided by him, and he says that on this basis, the deliverable supply is expected to decrease by 203 dwellings, i.e. a third of the year, on the council's own figures at the 1st of April 2026. Yeah, and this would have two consequences. First, there would then be 6 out of 7 monitoring periods where the council is unable to demonstrate a 5-year housing land supply, and the council's housing land supply would be worse in the next monitoring period than it is presently. Yeah,
I would presume so. I wouldn't.
Yeah. You don't advance any evidence to contest that, do you?
No, I don't. No, because I'm not doing a 5-year housing land supply.
Yeah. So, if you are right in your table that the weight that the inspector attributes to the provision of housing must be appraised in the context of the improvement in housing delivery since March 2025, it's equally fair, isn't it, that the inspector is cognisant of the fact that from the base date of April of this year, i.e. already passed, once those results are published, there will have been a deterioration in the council's housing.
Again, I respect Mr. Pycroft's position. I can't comment as to whether or not that's.
But what I'm asking you to comment about is you say the inspector should take into account an improvement for the year 24-25 as against the previous year. Well, there is uncontested evidence that the next housing land supply position will be worse. I'm just saying if you say the inspector should take into account an improvement over 1 year, if there's a deterioration over the subsequent year, he should take that into account too.
If this housing land supply position decreases, then yes, but that's standard practice across anything. I'm not disputing that we're not in 5-year housing land supply, but my understanding was that we had agreed that the material weight of the position that Mr. Pycroft gave and the position that Councillor Fittick has given is given the same material weight, and that's how my evidence has been pulled together on that basis.
Well, neither Mr. Pycroft nor Mr. Fittick are doing anything with weight. You're dealing with weight.
No. In the sense of there is no. They don't disagree. There is no disagreement. Let me rephrase. There's no disagreement in the planning weight attributed to those two figures. So we are not contesting 5-year housing land supply, and therefore, if we are to say that's that basically, okay, yeah, no, sorry, I get. Let me rephrase. We're not contesting there is a bridge and between the two, 3.6 to 4.04, and we are in agreement, and it's agreed with Mr. Fagan at the CMC that the position is that the planning weight between those two can be bridged, and there's not a significant difference within those, correct? We agreed that at CMC.
We agreed that the range was such that, well, the inspector concluded on the basis of the range that was offered that wouldn't materially alter his assessment of weight. What I'm dealing with is your assessment of weight versus Mr. Tate's.
Yeah.
I don't know what weight the inspector is going to give it. I'm advocating for substantial. You're advocating for significant. So that's what I'm exploring.
Okay.
One of the factors that you say, why you say significant rather than substantial is because you say, hooray, this year the council's position wasn't as bad as it was the previous year. The uncontested evidence is, well, that's fine, but as of now, as soon as the next housing land supply position is published, which presumably is due any time soon, it being summer, it will have deteriorated again.
I'm not contesting that evidence because I'm not in a position to contest that evidence because I'm not defending 5-year housing land supply.
All right. Okay. Right, there's a bit of a theme in terms of benefits that cut across a number of them. This idea that, well, this scheme isn't doing anything more than any other scheme would.
But if you say so.
Well, that's what I took from your examination in chief. You know, I moderate the weight I'm going to give to something. I give the provision of affordable housing significant weight instead of substantial weight because it's policy compliant. It isn't doing anything more than another scheme would.
Yeah, and I think that's something that there's been appeal decisions that have been that we've referenced that show that substantial weight is given whenever those go above and beyond.
There are a number of factors that go into the weight a decision maker gives affordable housing, aren't there? One of them might be the policy requirement. One of them might be the provision of affordable housing, the shortfall. One of them might be the acuteness of the need for affordable housing. Yeah. One of them might be what is the ratio of average house prices to average incomes in that district as compared to other locations. Yeah. So there's a range of factors. You don't just look at the policy and say policy compliant, therefore I can't get top weight, do you? I could be in a district that is got a 0.5-year housing land supply, producing very little, has an enormous affordable need, and someone comes along and says, well, the policy requirement is 30%, so I'm going to give you 30%. And you kind of, on your case, you kind of shrug your shoulders and say, well, it's only policy.
But that's not what we're not on that land supply position. I appreciate it's hypothetical.
Yeah, well, I'm just looking at your proof, and you know, your point is, in your summary table and from your examination in chief, is that whilst other schemes attracted substantial weight, the provision here is policy compliant rather than over provision. I therefore afford it significant rather than substantial weight. Your reasoning is solely that because it's policy compliant and not more than policy, you give it reduced weight as compared to Mr. Tate.
I give it in essence, the reason. Yeah, in essence.
That's your reasoning. I've just read your reasoning to you. Yeah, that is the reason you've given for reducing the weight as compared to, you know, because you say, I'm not giving it substantial, I'm going to give it significant because it's only policy requirement compliant. Yes. So that's the one reason. But we've agreed there's a number of reasons which feed into weight, aren't there?
Yes.
Yeah. We know, for example, in this district, there is a long-standing and acute need for affordable housing, isn't there?
Yes.
We know that average earnings are average house prices are 11 times average earnings. Yeah. Mm-hmm. We know that is higher than the national position, isn't it? We know that it is one of the highest in this region as well, don't we?
Well, just for clarity, are we talking about East Anglia? So
yeah. Well, I mean, I'm going to go to Jason Tate's proof and work through that. But you know, we can agree, don't we, that we have a significant shortfall in the provision of affordable housing. Yeah. We can agree that where an authority is not delivering a 5-year housing land supply, that position is inevitably going to further deteriorate, isn't it? Because it isn't providing enough housing, of which affordable housing will be a constituent part.
Yeah, I think that's a reasonable position.
Yeah. The problem is getting worse, isn't it?
Based on my, I can't say if it's currently getting worse or better. I don't have the evidence in front of me to conclusively say that.
All right. And then in terms of it actually being a policy requirement, affordable housing is always a benefit, isn't it?
Yeah,
if my policy requirement was 30%, but for viability reasons I can only deliver 5%, then that's still a benefit, isn't it?
Yeah, but it's subject to
there isn't some harm that my scheme is mitigating through the provision of affordable housing, is there?
No.
A single affordable house is a benefit.
Yeah, but the weighting one would give to
the more the better.
Yeah, of course. Yeah.
Okay. So it's important, isn't it, not just to look at percentages, but to look at numbers.
Yes.
Yeah. What you say in your proof. Or you refer to. I think is it Glebe?
Glebe Meadow.
Glebe Meadow.
Sorry, you're looking at some particular bit.
Well, I was just looking. I'm just trying to.
Yeah, yeah.
I've lost it
Yeah.
amongst my
Is it-
PDFs.
was it-
hence
was
the
it-
pause. Just trying to find which tab it's gone on to.
Is it?
Sorry. Thank you, Mr. Tate. So it is CD 9.6, Glebe Meadow.
I've got a hard copy.
Yeah, okay then. And if we turn to paragraph 54,
Yes.
the proposal would deliver 11 affordable homes as secured by the necessary planning obligation.
Yes.
Yeah. This is a significant benefit given the challenging local position with affordability.
Yes.
Yeah. I've not given this matter substantial weight, so we see here an inspector is clearly indicating that there's something higher than significant, aren't we? Because the inspector here is grappling with the difference between significant weight and substantial weight.
Yes, I agree
Yeah.
with that.
I've not given this matter substantial weight because 11 homes would be a modest contribution. Yeah.
Yes.
So there isn't any discussion there about whether or not it is, it's policy compliant. The consideration that the inspector was giving was the quantum of housing that would be delivered as a benefit. Yeah.
In that case,
Yeah.
sorry, I was just throwing it away and I've lost it again. Yeah, in that case,
Yeah.
yes.
And that's reasonable, isn't it? The inspector there was looking at the real world implications. It's all very, very interesting talking about percentages of this and percentages of that. But what the inspector was looking at there was the raw outcome. There's going to be 11 affordable homes. Yeah.
Yes.
And I'm going to consider the number of affordable homes that are actually delivered when I'm ascribing weight.
Yes.
Yeah. And in this case, it was 11 homes, wasn't it? That was given significant weight. Yeah. And we're getting on for triple that number, aren't we?
Yeah.
Yeah. Yeah. So that's something that the inspector should take into account, isn't it?
Yeah,
the actual number of affordable homes
in the
that
same way that in West of Malden, and I appreciate that the weighting point that you set out, but in the West of Malden, 110 affordable homes were being proposed, and they was given significant weight.
Yeah. Again, looking at the number of dwellings.
Yeah, which is more than what we are. The more affordable homes in that than what was being provided here as well. So it's just showing that, and again, I appreciate those can contest over the scales, and if one's allowed, tell me if I'm not. I can double check that, not right now, but generally in terms of the weighting, because there seems to be an issue whenever we refer to West of Malden, and I appreciate that exercise hasn't been exclusively carried out by the inspector as to establishing those weights. My memory, which has sometimes serves me, sometimes not. There was a higher threshold than significant in that land west of the Cemetery Road appeal. So
why don't you check that and
well, it's a procedural thing. I just want to if one is allowed to check that in the SOCG, and I can have a look now, but I don't know how long it would take me.
Well, try and have a look in the lunch break, and then you can let me know.
Okay. Yeah. No. I just again, this first time I've been examined. I don't want to break any procedural rules. That's all.
No, that's fine. Although one thing I would point out is that should Mr. McGarry go off and find what the appellant's scale was, that still doesn't help us as to what the inspector's was.
No, that's true. That's true. Well.
But then
see what you can find and
but then I suppose
yes. So it might not be worth bothering to do that then in that case.
Okay.
Yes. Okay. No, don't bother doing that then.
Okay, that's fine.
So just to finish up then on affordable housing, as we agreed in your table, you say the reason why you adjusted this, you haven't given it substantial, is because of policy compliance. Yeah, that it is just a policy compliant figure.
Yeah.
But we agree, actually, you should drill down past that. There are other considerations, including the quantum of housing that's provided.
Yeah, and I've
Yeah.
taken into material considerations
Yeah.
other appeal decisions where greater weight is attributed to schemes that are providing greater levels of affordable housing above the policy threshold, and that there's consistency in appeal approaches that policy consistent are given significant weight.
Yeah, but if I were to propose a scheme for 20 dwellings, and I said, actually, you know what, I'm going to give 50% affordable housing.
Mhm.
Yeah, I'd be 20% over policy, wouldn't I?
Well, in this location, yes.
Yeah, I would deliver 5 affordable homes. Yeah,
10.
sorry, did I say 20?
Yeah.
Okay. 10. All right then. 10. Yeah. I've got a scheme for 110 dwellings. Yeah. I decided to go policy compliant, so I'm going to provide 30 odd dwellings. Yeah. In the real world, I've delivered triple the number of affordable homes, haven't I?
Yeah.
Even though I'm only policy compliant.
Yeah, but whenever you're making those kind of planning decisions, you do bear that in mind. If you go with the
Yeah, but my point is, in your reasoning here, the only reason you've given is compliance with policy or over provision as against policy. That's the only reason you've given.
Yeah,
we agreed that's the only reason you've given. That's wrong, isn't it? There are other factors to consider.
Yeah, there are other factors to consider.
Yeah.
Yes.
Okay. All righty. Developer contributions, £310,000 toward public transport improvements. You say that's neutral because it would improve public transport connectivity between the site and other destinations. It goes toward public transport links, doesn't it? As I understand it, bus services.
Yeah, to mitigate the harm.
And there are also some highways infrastructure improvements in terms of drop curbs and what have you.
Yeah, to mitigate the development.
All of those things will not simply be to the benefit of future residents of the scheme, they'll be to the future benefit of anybody using those footways or those bus services, yes?
Yeah.
Yeah. So they can't just be neutral, can they? Because they benefit a wider proportion of the populace.
But it's my understanding that it's purely to mitigate the impacts of the development.
But it doesn't, does it? Because we've just agreed that the drop curb that makes the footpath more pleasant for users isn't just for the users of this site. The bus service that is supported will be used by people other than the occupants of this site, won't it?
Because my understanding is that the contribution is there to mitigate the introduction of the number of people that will be living at the new development. So therefore, it has been considered by Essex County Council Highways that contribution is required to address those points. Other people will have the right, of course, to use public transport, but fundamentally, they have come to the conclusion that that is there to mitigate the impacts of the development.
If the £310,000 supports, a more frequent bus service, an additional service, or if it sustains a service that might otherwise not have continued, that isn't something that affects only the future residents of this site, does it?
Yeah,
it affects everybody who uses that service.
Of course, it affects other people. But
if my scheme requires mitigation to a junction in terms of replacing a signalised junction that's congested with a roundabout, and I improve the traffic situation,
that has been caused by the development.
Yeah, it was necessary because my development caused it. But if I've actually got something that's better at the end of it, that isn't neutral, is it?
Well, it's only better if you're then comparing it is along the lines of if. My point is that if the development wasn't there, it wouldn't be needed.
But if the development wasn't there, then you wouldn't get it.
But because it's not needed.
Yeah, but the point is you can have benefit, you can have improvements that don't just fall solely on the residents of the scheme, can't you? For example,
of course you can.
If the funding were for if a scheme was coming forward and there wasn't a bus service in a village, and it provided a bus service, because to make the development sustainable, that wouldn't be neutral, would it? Because it would be providing a bus service to everybody who was in the village.
Yeah, but it was only needed because of the impacts of the development.
Yeah, but it's still providing a benefit to everybody in the village, isn't it?
Yeah, but in planning weights, my view is that it's neutral because if if your development wasn't there, the service wouldn't be needed.
So contributions on that basis that are needed can never be given any positive weight.
I'm not necessarily suggesting that.
Well, that does appear to be what you're suggesting.
I'm just saying that a contribution of, in this case, to mitigate the impacts of the development, when the overall planning balance, you would be getting that. You have to do that.
Right. Why have you given biodiversity net gain limited weight instead of neutral weight? It's required to be given as part of the statutory framework. You say, therefore, it's necessary for this development, and by the same logic, why give it anything other than neutral weight?
To be fair, I was actually toying with it, but I think that given the kind of history and the material evidence that has been put in front of me through other appeal decisions, that it should be given the material considerations of other appeal decisions where biodiversity net gain has been assessed, it seemed consistent that the biodiversity net gain, where it's slightly over the threshold, should be granted limited weight.
Yeah, well, I mean, that was my point. We're going to come on to BNG as benefit. I'm just exploring this idea that if something is needed, therefore it can only ever be neutral weight. The other example, again from your proof, is in this table is the provision of public open space and green infrastructure. Yeah. You say there is a policy requirement to provide open space. Given the site's location at the edge of the settlement, the new space, open space, will be of limited benefit to the existing community.
Yeah, I mean, given its proximity,
there would be a benefit to the existing community. You say it's limited.
Yeah.
But there would be a benefit to the community.
Yes.
Yeah, there is a wider benefit. You've given it limited positive weight.
Yeah, in line with...
The reason why that the POS is being provided and the GI is being provided is because it's needed, because the scheme, policy requires it.
Yeah, yes.
Yeah. So in that instance, you have said something is needed, but you've given it positive weight.
Yeah,
that doesn't tally with your highways infrastructure improvement point, that because it's needed, it can't get anything other than neutral weight.
Because the highways contribution is dealing with harm, or a negative effect that the proposals bring, and putting infrastructure pressure on things like public transport on the highway itself. So the assessment isn't necessarily, you're not comparing, in my view, you're not necessarily comparing apples with apples, because there is no, in this location, there's no public open space at the moment, and where we see, I think it's the Glebe decision as well, where we highlight the location and proximity of said public open space is on them. When granted, it's not completely inaccessible, but on one of the more inaccessible locations of this site in terms of the northern boundary. It was given limited weight as well. I saw no reason to diverge from that in terms whenever I'm assessing its weighting in material impacts. I understand the logic of what you're saying, i.e. there is mitigation, there is other people are going to benefit from the highway's improvements, but it's only because the highway at its current, and the public transport position in its current form is unable to accommodate your development.
Okay, can I try it this way? I just want to understand your position so I can record it. So
okay.
Tell me whether I've got this right or wrong. Are you saying that where you have a harm that needs to be mitigated, regardless of whether the solution has a wider benefit, it can only ever be of neutral weight?
No, I'm not saying that exclusively.
So, if you're not saying that, and in fact the contributions in highways terms do have a wider benefit, then they can be afforded some positive weight.
Well, I think that we're talking about these benefits and on this site, and my view is that in this case it is neutral.
Yeah, that's fine. That's assessing what it actually is. But your initial position was, as a matter of fact, because something is needed, it can't be.
Well, it was said in the context of this site,
and I'm glad we've clarified that.
Well, I would say in context of this site, just to be, and these mitigation measures. That's why we have afforded neutral weight.
All right. BNG, statement of common ground. We've agreed with the council moderate weight.
Yeah, again, I appreciate that, and that is unfortunately another.
What's the council's position to this inquiry?
Well,
The statement of common ground or the witness the council has produced?
well, my position is that it's
Not my question. Do you know what the council's case is to the inspector? The council has signed the statement of common ground that says BNG should be given moderate weight. They have asked a witness, you, to turn up and say, oh, I was toying with the idea of neutral and I'm limited. I don't know what the council's case is. I'm not sure the inspector does. Are you able to help us?
I can only give my professional opinion and my.
But no, you're instructed by the council.
Yes.
What weight does the council say should be given to BNG?
I think
because it's agreed moderate.
Well, I think based on the documents that have been issued, obviously the statement of common ground says moderate, and my professional opinion is that it's limited.
It'd be unreasonable behaviour of a local planning authority to agree something in a statement of common ground and then turn up to an inquiry and say something different, wouldn't it, with no change in circumstances?
I think that, again, I'm purely giving my professional opinion. And
but you're the council's witness, so you don't agree with the council, what the council has agreed?
Evidently not, no.
Sorry, where in this statement of common ground does it say that?
There is 10.4. At the end of that, it says it should attract at least moderate positive weight.
Yeah, it's under the ecology section.
Yeah. Should
At least, yes.
attract at least moderate positive weight. Yeah, okay, yeah.
So when you were preparing your evidence, did you have regard to the statement of common ground and what the council were agreeing? Were you the author of the statement of common ground? Did you have any input into it?
I assisted in the drafting of it, yes.
Okay. So you assisted in drafting a document that agreed at least moderate weight? Yes?
Yes,
And then you proceeded to write a proof that says limited weight?
in further consideration, yes.
Yeah. Who would you say is being unreasonable here, you or the council?
That's not necessary for me to kind of comment on. I suppose that's for the inspector to comment on.
Just to be clear, do you go with the statement of common ground, or do you go with what you said?
My professional opinion is what is set out in my proof and limited.
Yes. Okay. Fine. Yeah.
Okay. Might I ask, it's slightly unusual, but might I request through you, sir, that over the lunch break, when the witness has finished giving evidence, that he takes instructions as to what the council's position is? Because I hear what his view is. Does the council stand by the statement of common ground that it's signed, or is it?
Yeah,
is it changing its position?
That's fair. That's a fair point. Yes. Let's hear that from the council. Yes.
Okay. So in terms of the weight itself, your professional opinion, you say, is that we only get to the statutory minimum. Now, a little bit like affordable housing, which is a policy requirement. Yeah. BNG, the requirement to provide BNG, all of it's a benefit, isn't it? 1% BNG is a benefit, 2% is, 3% is, 4%. It's all positive.
Yeah, if you were only doing 1%, you wouldn't be compliant with the statute.
Yeah. But the point is, from 0.001 onwards, it is a positive thing because it is a gain.
I mean, it is a gain, yes, but I mean, the way one of
it's certainly not a harm, is it?
No.
And yes, it's a statutory requirement, and the previous government decided that biodiversity gains were of such importance that it was worthwhile spending parliamentary time drafting legislation, taking it through consultation, using parliamentary time to set a statutory minimum that should be provided. Yes?
As any statute has to go through parliamentary time, but yes.
Yeah, and parliamentary time, we always hear, don't we, well, there's only enough parliamentary time in this term to deal with X, Y, or Z. There is a choice, isn't there? Parliamentary time isn't
I'm not sure what the relevance is.
Well, the government decided it was so important to legislate for at least 10%. Yeah.
Well, yeah, that's the legislation, yeah.
Yeah. To bother doing that, it must be a benefit of some significance. Otherwise, why bother
Well,
spending all that time going through Parliament and legislating for
well,
it?
I can't comment as to the amount of time spent doing it or the relevance it has to this case in terms of parliamentary time. But
Well,
fundamentally, it is legislation, and that's what I'm here to.
It goes to the fact that the government of the time saw it as a good thing, didn't they?
Yeah,
Yeah.
yeah.
So good, in fact, that they were going to use time legislating for it. It was something worthy of legislating for.
But yeah, and yes.
Yeah. What it wasn't doing was setting a bar of, weightings in any way, was it? It was the whole purpose of it is to seek gains through all development.
But that wasn't its. Yeah, of course, it wasn't setting planning balance or planning weightings within the legislation. That's not the purpose of it.
Yeah, and we need to drill down into this. So we have 10.59% habitat gain. Yeah.
Yep.
Which you say only marginally exceeds the floor. Yeah.
Yep.
But it's still a 10.59 gain, isn't it?
Yes. Yeah.
It's not a 0.59% gain because it only marginally exceeds the 10%. It is, from the present position, a 10.59% gain in habitats units.
Yes.
Yeah. And equally, it is a 38.11% gain in hedgerow units.
Yes.
Yeah. The 38.11% is, I appreciate it all gets put into a single figure in the end.
You don't read them separately.
Yeah, but in terms of, we don't have any watercourse units on this particular metric.
Yeah, but therefore wouldn't be.
But it's clear that we are exceeding the statutory minimum, aren't we?
Yeah, and I accept that.
Yeah, and the statutory minimum, even just the statutory minimum, is a benefit, isn't it? Because the statutory minimum is a 10% improvement on what we've got at the minute.
Yeah, but and this is my point is I accept it's a benefit. I identify it as a benefit. The way that I give it is limited because again it is one of those points where yes I accept the discussions we previously had about need and requirements etc. And the way they should be approached. Agree with that. But again, it is something that you're legally you're legally obliged to do, and again we let me just sorry my brain's running a million miles a minute here. The point being that simply carrying out and complying with your legal obligation, though it is a benefit of which I've given limited weight, I don't think that it should. My planning position is whenever assessing it in the tilted balance, doing something one is legally required to do, approach that benefit is limited weight. That is the same position that the inspector has taken with the land west of Malden as well. So this was post my proof. I can't remember specifically what their percentage was. I can find it within the land west of Malden position if you afford me a little bit of time, but
I don't think we really need to dwell on this as far as I'm concerned.
Yeah, but the inspector.
One of my decisions was challenged on the basis that I'd given it limited weight and failed. So
the challenge failed.
The challenge failed.
Yeah, and I mean it's also consistent with in paragraph 81 of the, just for your reference, 81 of the land west of Malden, they applied limited weight as well. So it's a consistent theme. And I appreciate the frustration with the statement of common ground as well. I do highlight that, and I will discuss with the council in the lunch break.
Okay.
Okay, economic benefits. Yeah, I'm hopeful to finish up, and then if you're happy to continue.
I'm happy to continue. More than happy to continue. Yes.
Wonderful. Yeah, economic benefits. You say these are standard economic benefits. Construction spend. You were saying, well, it's the same as other schemes. We get economic development on other schemes. That's what I took from your examination.
That's the intention. Yes.
Yeah, but I mean, the first thing is, if you're in an authority that isn't building enough houses, then you're not getting as much in that district as you should be getting, are you?
I mean, you could make that case, yes.
Yeah. Well, I do. Do you disagree with it?
I don't. Not in the overarching premise, but whenever I apply planning weight to it, I highlight that it is a benefit. Let me just find it in here, just so I'm making sure, and I give it moderate weight.
Yeah. And in terms of economic growth, there isn't any cap on that, is there? There isn't a case of Rachel Reeves now obviously out of position, but for the last 2 years we haven't heard anybody saying, well, we do need economic growth, but only really to this level, and beyond that, we're okay. It is a good thing, regardless of if someone is spending £20 million building something, on the other side of that field. If someone comes along and wants to spend £20 million of capital investment on a different site, that is additional, isn't it?
I'm sorry, maybe my brain's probably weak.
Well, your point
could you just rephrase that, please?
Well, your point is, they're just the sort of benefits you get on other sites. That's what I understood your examination to be.
Essentially, yes.
Yeah. So, when someone comes along, for example, and proposes an employment scheme in this district, you said, oh, well, it doesn't create any on-site jobs. Do the council say, well, that's great, we want employment schemes? Or do they say, well, it's only just like any other employment scheme, so therefore I'm going to temper the weight that I give it?
Well, I mean, I'm not talking about an employment scheme.
All right, then.
But
we're saying we're going to come along and spend nearly £20 million, okay, and we're going to create, whatever it is, 190 full-time equivalent jobs over the course of the construction period. We can go to it. It's set out in Mr. Tate's brief.
Yeah, I've seen it.
But they're chunky numbers, aren't they?
Relative, they're the numbers one would expect relative to the size of the scheme.
Yeah. When someone comes along and Rachel Reeves is thinking about her next budget, and someone's saying, "Oh well, I've got this authority," and someone came along and they said, "Well, they did want to proceed with something, and there would, there'd be £20 million, and there'd be these jobs, etc., etc." And the council said, "Well, I would have given it more weight, but it's no different to another scheme, so I'm going to temper the weight that I give to it." That isn't appropriate, is it? Just because someone else is producing £20 million worth of investment and employing people, it doesn't reduce the value of my £20 million investment and the jobs I'm creating, does it?
I'm maybe really struggling with the question, because my understanding is we're assessing the planning weight that should be given to it. I'm not suggesting that Malden are averse to investment coming in. What I am saying is that the benefit to which I identify this is a benefit. I give it moderate weight in the planning balance. That's my point. I'm not suggesting that it's not. That is also the position that's held in Malden West, the cemetery appeal as well. Whenever the inspector considered that, which was a larger scheme. My view is that the economic benefits associated with this are to be expected, and again, we appreciate that the site will be developed. It will provide jobs. I'm not disagreeing with that. It will increase council tax revenue. I'm not disagreeing with that.
Right.
But whenever
your case isn't the case that pops up occasionally, which is, oh, these are generic benefits, therefore I give them reduced weight. That isn't your case.
My view is, well, they are important yet generic. You obviously council tax income is important for the council. Obviously, the provision of jobs are important to the economy. I'm not suggesting that they aren't important, but they are to be expected with a development of this scale.
But when someone comes along and proposes a solar farm, and I say, well, what weight am I going to give this in terms of the contribution toward hitting the net zero target? Does an inspector say, well, you know, it is going to do that, but so would any other solar farm, so it's generic, so I'm going to reduce the weight?
I haven't dealt with solar, so I couldn't possibly say. I think I understand your point, but my position is that this, in the planning balance and the tilted balance, in accordance with other decisions, relevant decisions and other material considerations, this is a moderate benefit in the tilted balance. It's still a benefit. I'm not denying that, and I'm not suggesting it's not important, but I'm just giving it important. It's the weight in my professional planning opinion.
Right. I appreciate you've undertaken the planning balance on, you know, the basis of the harms that you set out. Should the inspector reach a conclusion, having heard all of the landscape evidence, including the agreed tables, or all of which, as we've been through, don't exceed moderate, should he ultimately ascribe moderate weight to the landscape harm? Yeah. Then we're in a world where we're in the tilted balance, and obviously we've got significant benefits in terms of provision of market housing and affordable housing, and we've got other benefits on the other side. On the council's case, we would have landscape harm if that were moderate, and if there were moderate weight afforded to the occupier of number 48, and limited weight to heritage. That's it, essentially. You know, in terms of significantly and demonstrably, does moderate landscape harm and moderate harm in terms of amenity outweigh significant benefit of market housing, affordable housing, moderate economic benefits?
I think that it would be unreasonable for me, given the fact that I have said that it is a finely balanced view, that if the inspector did take a differing view in terms of the weightings, that would obviously have an effect on, that would probably have an effect on the outcome. I can't speak for the inspector, but my view is if the landscape and visual harm was considered to be moderate, that would have an effect on the tilted balance, yes.
Yeah, an effect on the, as you said, your position is, on your case, it's finely balanced.
Yes, yeah.
The effect would be that it tilted in favour of approval.
More than likely, yes.
Thank you very much.
Okay, thank you.
Any re-exam points?
Just a couple, please, so hopefully quite brief. You were asked some questions right at the very beginning of cross-examination about the withdrawn reasons for refusal, which ultimately, reasons for refusal that were put forward by members, but which ultimately aren't being defended by the council at this appeal. Despite those reasons for refusal having fallen away, what is the council's position at this appeal as to whether permission should be granted or not?
The position is that, given the tilted balance, our view is that planning permission should not be granted.
And your professional judgment, therefore, as to whether members were correct in their overall assessment to refuse planning permission?
In line with the reasons for refusals that we are defending.
You were asked various questions about the Homefield appeal decision, and various distinguishing factors between the landscape harm identified in that decision and the landscape harm identified here. Are you saying that the inspector here should reach the same conclusion as to the level of landscape harm as was reached by the inspector in the Homefield appeal? And so in terms of any differences between the extent of landscape harm identified at Homefield and this scheme, is that reflected in the level of weight you've attributed to the landscape harm?
Yes.
And then just finally, in terms of developer contributions, quite a lot of questions around that, but as far as you're aware, does Mr. Tate give any weight to developer contributions as a benefit of the appeal?
I think he does. Off the top of my head, I would need to double check exactly what those weights are, but
You think he does?
He does identify them as a benefit.
Okay. I can ask Mr. Tate about that. Thank you. No further questions, unless you've got any questions.
That's fine. Thanks. So it's 1 o'clock, so yeah. Yeah, so I'm just wondering how long we need for lunch and how long we're going to take with Mr. Tate. So in chief, with Mr. Tate, roughly?
I think 40 minutes.
Yeah, okay, okay.
40 minutes.
Yes.
But yes, certainly.
Yeah, yeah, okay, say 45 minutes.
We've covered a lot of ground anyway. So.
Well, of course we have. Yeah, it always gets quicker with planning, doesn't it? Yeah. And roughly?
I don't think I should need more than an hour and a half, and hopefully
Say an hour
if
and
I
a half.
say an hour and a half, because I always underestimate.
Yeah, yeah.
So, but I think I'd be grateful for an hour for lunch so that I can try and see what I can cut back.
Yeah, okay. Well, we agree. You don't need to look it up as far as we're concerned, but if you want to discuss it, well, feel free. But yeah. Yeah. No, I'm not asking you to provide anything else about that. So we'll come back at 2 o'clock then. Yeah. Okay, thanks. Is everyone who's going to be here? I think we are. Well, we may as well proceed then. So over to you, Mr. Hawley.
Thank you, sir. Afternoon, Mr. Tate. You are Jason Tate. You hold a BA Honours degree and postgraduate diploma in town planning. You are a member of the Royal Town Planning Institute, and you are a director of planning and development consultants, Planning Prospects Limited.
That's correct.
You have over 34 years experience in planning and development. You've worked in private sector planning and property practices, and Planning Prospects is, I understand, a company that you co-founded.
I did, yeah, 20 years ago.
Okay, so you are no stranger to the public inquiry format. I'd like to start at the end, as it were. Planning balance. We heard the council's evidence, Mr. McGarrity. On the council's evidence, the planning balance, which we all agreed is the tilted balance, is a finely balanced matter. The scales are quivering over approve or dismiss. In terms of your view as to the overall planning balance, is it finely balanced?
I don't think it is a finely balanced case in this instance. We had a scheme that was recommended for approval by officers. We've got members who overturned that recommendation for a number of reasons, many of which have fallen away. The harms that have been alleged now, that are residual harms that are left, are, in my view, relatively modest and moderate, and the benefits in this case are significant and substantial. And I think against that balancing exercise overall, it's clear to see that they do significantly weigh in favour of the proposals, never mind on a sort of flat balancing exercise, but where we are on a tilted balancing exercise here, I think we're a long way from getting to a position where the tilted balance would weigh against these proposals.
Thank you, Mr. Tate.
Well, is that it?
Yeah, we're all done.
Okay, right. I thought you were just going to cut to the chase.
Cut to the chase.
That's it.
Should the inspector approve this scheme? Okay, so we know what your position is. We know that there's some debate over how those matters fit into the planning balance. Someone at the front door. Putting yourself, we heard from the council in terms of landscape harm. Obviously, we've been through that. I'm not going to turn up those tables, what have you. We've all heard and heard it. The council say significant weight to landscape harm. In your view, and that was said to be a matter of planning judgment, which it undoubtedly is. Do you think it's or do you consider it a reasonable judgment to say there's a significant harm in landscape terms given the evidence in this appeal?
No, I don't think there is. I obviously adopt a planning harm because there will inevitably be some planning harm of building houses on a currently open greenfield site. So I don't dismiss that harm. I do recognise the intrinsic character and importance of the countryside, beauty of the countryside, and weigh that in the balance. And I come up with a moderate harm in that regard. So it isn't something that I dismiss, but I do rate it more modestly than the council at a moderate level.
Yeah. And in terms of the council's case, obviously we had a recommendation for approval, and then we had a number of reasons for refusal, some of which have dropped away as we've gone along. What do you say about the council's members' decision to refuse, as compared to the reasons for refusal we're actually dealing with now?
Well, different to the council's witness, I do think it has some relevance to note that the situation that the council are close to special measures, and they're close to special measures on the basis that decisions contrary to officer recommendation and situations where they've lost appeals are having an effect in terms of what potentially could be the way that applications get determined in this authority in the future. The situation for me that I find hard to understand in this case is that the members made a planning balance judgment themselves and came up with a range and raft of reasons. And it's not just the odd one, but quite a number of them have all fallen away. So traffic, light pollution, air quality, getting the best and most versatile agricultural land grade wrong, etc., etc. So in their planning balance judgment, perhaps it would have been appropriate for the council to have a reconsideration of the overall planning balance and refresh that decision that they actually made. But obviously the position that the members decided on at that point is quite a significantly different position to what the council are now arguing, and I can understand why the council witnesses even find it very difficult to get more than just a finely balanced judgment that planning permission should still be refused.
Thank you. Now, in terms of the development plan, because that's our starting point, at para 3.6 of your proof, you tell us that the most important policies are policies S1, S2 and S8. So if I could ask you to turn up the development plan, and we'll start with S1.
And that's obviously just to point out that those are a starting point for the most important policies regarding the principle of development of the site. And then there are relevant policies that flow on from that, but obviously the terminology for most important is quite important in terms of the framework and the utility balance.
Okay. So policy S1, that's page 14 of the plan.
Yep.
What do you say about what policy S1 requires and whether or not the scheme complies with it?
So policy S1 is an overarching policy that relates to sustainable development. It has a number of different components to it, and it's generally reflective of the definition of sustainable development, which was in the framework at the time this plan was adopted, which obviously was the previous framework to the current one. It has a number of different components to it, and those are sort of relevant to some schemes and not to others, but they're sort of overarching general objectives. I don't see any of those elements specifically in terms of the specifics of how those sub-elements 1 to 14 are written, that you couldn't form a judgment that says, well, in the circumstances we are here, this scheme does sensitively consider and reflect those overarching general objectives within policy S1, and that's what I've done in my evidence to say I don't see an inherent policy conflict with policy S1. I see it as a very important policy because it actually has that tailpiece in it that gives you the development plan solution to what you do in the development plan application, so the application of the development plan in circumstances where policy is out of date. So we're in those circumstances now, and the development plan is telling you how you do it within a development plan solution. So that's why I see it as quite an important policy.
Yeah. Okay, thank you. Policy S2, strategic growth.
So S2, again, an important policy because that's a policy that tells you overall what the strategic direction of growth is in the district, and the plan sets out that strategic direction of growth. And in broad terms, it's saying that, you know, the majority of growth will go to the larger settlements and urban extensions to Malden, Heybridge, Burnham on Crouch, etc. And that's where the vast majority of growth will go. It then goes on to say a proportion of new development will be directed to rural villages to support rural housing needs, etc. But obviously that's a more modest level of growth than it would be than in other locations. So that's basically what that policy is trying to do as a sort of direction of strategic growth. And again, in my evidence, looking at that policy at face value, I don't see anything inherently in conflict with these proposals, which are still relatively modest in scale and proportion to Southminster, compared to the vast majority of growth which is still going to be going on at the major and main settlements. I set that out in my evidence to say, if you look at the proportion of growth that we're proposing for Southminster, it's very much commensurate with that overall spatial strategy. So again, I don't see any particular conflict with S2.
Okay then. So then turning to policy S8, that's at page 45.
So S8 is different on the basis that there is a direct conflict with policy S8 from the development proposals. So the proposals, this policy relates to settlement boundaries of the countryside, and in very simple terms, it says within settlement boundaries you can build houses, and outside of settlement boundaries you can't, essentially, you can't build houses. There may be some exceptions to that, but we're not applying for those type of rural exceptions or different types of policies. So there is a direct policy conflict with this policy in that we are building houses on the countryside outside of the settlement boundary. Now, that is a part of the development plan which we are in direct conflict with, and I can't say anything other than that, and that's clear from that policy. However, as a most important policy, that is a policy which the framework says is out of date. Where that exactly takes you being out of date, then you need some judgment to say, well, what weight would you apply to the conflict with an out-of-date policy? And in circumstances where the council are clearly struggling to meet the minimum housing land supply, we need to apply that policy with some less rigour, because if you just continue to apply it with the same amount of rigour and say, thou shalt not build houses in the countryside, we end up with a situation where you just won't meet the housing numbers. There isn't capacity within the urban areas, and there needs to be some breach to allow some extra flexibility in order to deliver the housing numbers. So yes, we breach that policy. Yes, we're directly in conflict with it, but it's a policy that is out of date, and applied with full rigour will just be in the same situation of frustrating housing delivery.
Okay, so looking at this policy, that's the part below the table which sets out the settlement hierarchy, which we all agree.
Yeah,
there's no issue there. That's the sentence where we've got outside of the defined settlement boundaries. So
yes,
that's where our conflict arises, and your point being that if you apply that with full vigour in a situation where there is an inadequate housing land supply, then you'll never solve the problem. That goes to the weight that I give to that part of the policy. This policy doesn't just deal with settlement boundaries, it also tells us to a degree how we are treating the countryside. You heard the debate this morning, it says the countryside will be protected.
yes,
for its landscape, natural resources, ecological value, as well as its intrinsic character and beauty. It also says planning permission for development will only be granted where the intrinsic character and beauty of the countryside is not adversely impacted upon. What do you say about that bar of I will grant permission only if there's no harm to the intrinsic character and beauty of the countryside? I will protect the intrinsic character and beauty of the countryside. What do you say about consistency of that with the framework?
yeah. So I had the discussion earlier on, which I don't agree with the council's witness in terms of the approach that was taken. Some might remember the old PPG 7 and PPS 7 back in the day, and there was a distinct change when the new framework came out in 2012 and replaced the PPGs and PPS. But the old PPS used to say protect the country for its intrinsic value, and that word protection was a clear element of the former PPG and PPS, but it was specifically changed in the 2012 and has been carried forward in subsequent versions of the framework to use the word recognise, because it is balancing, I think, the need for development to take place with obviously the value that still can be attributed to countryside, but also giving different layers of protection to different elements of countryside that may have some higher status, the national landscapes or valued landscapes, and those were the elements that were retained as protected, whereas the countryside obviously needed a more nuanced or balanced approach. Now that's not to say that we build all over the countryside and don't save it for its intrinsic value and beauty, because we do that, and this policy could do that even with a recognised term in it, if it was an up-to-date applicable plan. So applying this in circumstances where policy was not out of date and housing supply was delivering to the minimum it was required to deliver to, then you would give significant weight to recognising the value of the countryside for its intrinsic value and beauty. But I think you need to temper that, because we need to deliver the housing supply, and that's a significant component of sustainable development and the need and the requirements of the framework to plan to meet the full needs of the area.
Okay. New development plan, some way off. What do you say about the ability of that to provide a solution to the present issue of a persistent and ongoing absence of a 5-year housing land supply?
Well, in this local authority, it's nowhere near providing any degree of alternative direction to solve the housing problems that this council have got. The Regulation 18 version was a number of years ago, and the council has, I think, suggested in the LDS they'll run another Regulation 18 before then proceeding to further stages. So it's got many subsequent stages to go. In fact, I think it's probably missed deadlines for progressing with the previous system would have to run into the new system. So I think that plan as a solution to housing problems and housing delivery is not going to solve the issues that the council have got.
Thank you. Yesterday we heard evidence about noise. I'm not going to rehearse the parties' cases, simply to say that obviously Mr. Healy was of the view that the proposal was acceptable in noise terms. Mr. Bryant was not. But there has been discussion about an acoustic fence. In terms of the scheme that was assessed, again, it's common ground now that there are alternatives to that to be dealt with at reserved matters stage. What is your understanding of how that will be dealt with? What's the process that will govern that? What control will the council have? And what effect in noise terms will different solutions have? I appreciate there's 3 questions there, so I apologise.
Yeah. Okay. So obviously listening to this week overall, some of this has been brought out by circumstances of how we've sort of got to here. Obviously, at the time the application was determined, and the time of the application submission, the applicant was clear that this was a scheme that was outlined, all matters reserved, other than the principal means of access to the site from Queensborough Road. And to avoid any ambiguity about any illustrative plans or drawings showing roads in different alignments coming into the site, at some point somebody put it on some dotted lines. I think the inspector, I think you mentioned it at the start, there's some dotted lines. And those are not by coincidence. They were there to sort of highlight to people that that road is really not a road that we're actually applying for at the moment. It could go there, and in actual fact, in the statement of case and in other submissions within the inspector's probably seen, there are a number of different alignments that go in a completely different direction over the other side. There's a number of different factors that are applying to that, because there's a requirement to maintain access through to the whatever we call it, the builder's yard, which has still a right of access, and that needs to be coincided, aligned, etc. But there wasn't an intention to get to this sort of forensic level of detail about this road and this fence. And I had some sympathy for the council's noise witness who sort of said, well, I've assessed this because I was told it was fixed, etc. And therefore that's what I've assessed. Well, yeah, it's not fixed though. It's an illustrative framework, and the road has got a number of permutations that it can be pulled away from the boundary and the requirements for the submission of the noise fence and whatever acoustic attenuation is needed, it would be subject of a planning condition, as there always was. It's not a new suggestion for some type of acoustic barrier to be put up to protect number 48. In fairness, though, at the time, the council, the EHO had only really identified a problem or an issue with the back garden. So that fence was only really going to deal with the back garden. But now, as it transpires, now we've seen all the evidence, the actual issue is with the windows. But, you know, there's still a performance that could be achieved with that fence and the location of the road that as the noise witnesses said yesterday, both of which said, you know, move the road further away, put the fence nearer the noise source and not near the receptor, and you know you'll have significant changes in the circumstances of how the noise affects the property. So none of that particularly worries our acoustic consultants. But in terms of the approach, yeah, there's two factors there. One is reserve matters are needing to be submitted. That reserve matters will deal with the layout of the development, including the layout of the road that runs through that parcel. And then there is as there always has been, a condition which we've put some extra detail in that condition to the council yesterday. I appreciate you haven't seen it yet, sir, but put some extra detail into that condition to put some noise levels associated with that into that condition to give you some additional assurances around noise levels, and that would deal with the acoustic attenuation that would be required for the property. So everything's there really for this to be not a matter that needs to concern you, sir, at this stage, but can be dealt with at the reserve matters in that condition stage. That acoustic fence will need to have a performance that will give assurances for the protection of that property from the potential for noise, and in combination with the location of the road, which is also up for future reserve matter submission, and the location of the fence and its height, etc. There was a comment, sir, that you mentioned about the height of the fence being, I don't know if it was a throwaway comment. The point was that nobody knows what the height of the fence is, but just to put it in context, in my experience, like a 4 or 5 metre high fence would be, I mean, I've got schemes that are on the edge of a motorway junction, and we're still not even at that sort of height. I mean, I think keeping this in proportion, this is slow moving traffic generally, entering a site quite modestly in speed, coming into a site where there's always going to be a bend to go into the site, the main bit of the site, because it's off over to the left as you go in, or if you're coming out, you're approaching the junction, so you're going to be at relatively modest speed, to a road that's designed at 20 miles an hour, different to Queensborough Road, which is at 30, and a very modest number of vehicles, particularly in the nighttime period, which you know, not all of them are going to be at the highest levels that certainly the council, I mean, it just couldn't realistically be the case with a bit of rationality and a bit of common sense. So just putting it in proportion, really what the council have done is, you know, taken a design for a road that was illustrative next to a boundary to a situation where they've now identified with an upper floor window and a fence that was proposed in respect of garden noise, applied the highest potential for noise over those periods against some standards from the 1980s that related to aircraft noise, and then said there's going to be a fundamental problem. And I think that doesn't, you know, pass the sort of common sense test, really. There's everything into play here where the reserve matters can deal with this in a sensitive way, with a road in an appropriate location, with an appropriate proportionate barrier, and that will be covered by a planning condition that will ensure the acoustic performance is achieved to the property.
Thank you. Now, we mentioned the condition, but I did notice some discussion just on the other side there. I suspect neither my learned friend or Mr. McGarrity have seen it, so you have not seen the wording. So it is.
Yeah, I haven't seen the draft when we discussed it.
That's okay. That's fine. That's fine.
I was just, I wasn't sure. Maybe you were saying if there had been something sent across to the this.
There has been something sent across to you and to yesterday lunchtime.
Okay, well, I haven't.
Yeah, that's okay.
Yeah. So obviously you've asked for a condition anyway, sir. So we've provided one, and we'll discuss that in the condition session.
Yeah.
So I'm not going to say exactly what the condition is going to do, but it's clear that the condition is going to deal with noise. It's going to give the
It's not a
council...
new condition, it's just the same condition that was in
it's
the
an
original
amendment,
list
yeah.
about providing an acoustic barrier to protect the acoustic.
26,
Yeah,
condition
to-
26,
to,
I think. So
ensure
it's,
that noise is mitigated from traffic from the access road onto the adjoining property.
it's some additional elements to that. So with the imposition of such a condition, or indeed the condition as was, if permission is granted for outline and the applicant comes forward with a scheme, a reserved matters stage where the road layout can't be demonstrated to the council, let's start from the premise of the appellant's position on the evidence is that there is no issue here. You can have any permutation.
Yes.
And there is not an issue for number 48 because we are at the lowest observed adverse effect level, not the significant observed adverse effect level. That said, even with lowest observed adverse effect level, the instruction is to minimise so far as possible. So it would be incumbent to move the road or adjust the location of the barrier with it in order to minimise even a lowest observed adverse effect level. If the council, upon receipt of whatever details are put in, that road configuration with an acoustic, a fence, we were referring to it as an acoustic fence. It's just a solid timber fence from the specification that's being given.
Yep.
If the council take the view that, well, I'm not satisfied, that there would be harm. I've got an acoustic assessment on this particular scheme and I'm not satisfied. What can they do in terms of that reserved matters application or the discharge of the condition? Can they?
It's entirely down to the council, isn't it?
Yeah.
If they're not satisfied with the details that it doesn't provide the acoustic performance, then they don't discharge the condition, do they?
Yeah.
And that'll be a matter for another inspector, maybe. Who knows? But the upshot of it is that it's entirely within the control of the council. And with regard to visual matters in respect of any noise, fence or whatever, then again, it's another matter. If the answer was a 4 to 5 metre fence, then ultimately, the council may have a view of that's suitable from a design perspective and would refuse it for visual reasons associated with its appearance. So it's in the full control of the council through the reserve matters and the discharge of conditions.
And just in terms of any potential fence heights, obviously, as we say, we've always proposed a 1.8 in that location. Discussion with Mr. Bryan yesterday, obviously a point that you've made, that you put the mitigation near the source, not near the receptor where you can, because that's the way to deal with noise most effectively. Mr. Bryan accepted that if one moved the road away and had an acoustic fence of 1.8 metres at that location, he was comfortable that at the very least it would deal with the nearest part of the carriageway.
Yes.
Yes,
Yeah,
entirely, which would be what percentage of the vehicle movements?
Well, it'd be the same in and out, wouldn't it? So at least half of them.
Yeah, and his view was obviously the outer bit of the carriageway would be subject to assessment and it may or may not deal with that. So in terms of that, how comfortable do you feel that even if the council were right in its evidence, that there is a design solution which is acceptable in terms of location of the road, height of the acoustic barrier, the full package?
Well, obviously the acoustic consultants would do the appropriate calculations, but there's plenty of flexibility in terms of dealing with the matter. The road isn't only on that alignment, so first off the road would move further away, and second the barrier would be closer to the noise source. As the council's acoustic consultant said, they'd probably readily deal with the carriageway nearest to the fence fairly easily. It needs some further assessment to make sure it did the furthest carriageway. Well, yeah, I mean, you're talking about a line of sight from a road which would be much further away with a fence that's very near to the road, as opposed to being on the boundary with the property. Because you wouldn't put it on the boundary of the property. It was only on the boundary of the property in that illustrative example that they've been working through, because the road was next to the boundary. But if the road was further away, you wouldn't put it on the boundary.
Okay. Now, obviously, we know the council's case isn't notwithstanding the way the reasons for refusal are set out, the council's case as put is that this is a moderate harm to weigh in the planning balance, that if this were the only issue and the council's evidence were right and accepted by the inspector, it's not. That is a standalone issue for refusal. It's put as a moderate harm to weigh in the planning balance.
Yes.
Your planning balance doesn't incorporate any harm for that element because you rely on the evidence of Mr. Healy that says there isn't an issue. Yeah.
Yes, exactly. So if it's an element that's not harmful, I'm not going to weigh a harm in the balance. But and obviously, I'm taking the advice from our noise witness. But yeah, I mean, I suppose the alternative is, the worst case scenario, the council weigh a moderate harm in their weighting, which is their view of that. But I don't weigh that harm in that way.
Okay, so moving on to the other benefits then, in terms of affordable housing, and turning to your proof. Page 22 internally, page 24 on the PDF. This is all under the heading of housing, land supply and need for more housing. So you're dealing with market and affordable housing in this section. 413 onwards, you discussed the undersupply in Malden that we know has persisted for 5 out of 6 years, and we understand from Mr. Pycroft's evidence will be 6 out of 7 years. You say, you make a point about, well, that absence of delivery and therefore the absence of delivery of affordable housing on those sites. What difference does the council's seeming inability to maintain a 5-year housing land supply, what influence does that have on affordable housing provision in the district?
Yeah, my paragraph 4.13 is highlighting the point that if the council had delivered a minimum 5-year land supply or exceeded that, but at least delivered the 5 years, then if you assume a 30% provision, I know there's actually in policy some sites require 40%, some slightly less, most other sites require 40%. But assuming an average of 30, then depending on whether you accept Mr. Pycroft's or the council's evidence on housing land supply, that's 191 or 273 dwellings, affordable dwellings that would have been delivered. So these are real affordable homes that unfortunately are not getting delivered because the council aren't meeting the minimum 5-year land supply requirement. Yeah.
Now, of course, this isn't the only council that isn't meeting the 5-year housing land supply requirement. But it is, we look at 414 and you provide some statistics there. It is by reference to ONS data, by reference to the council's issues and options paper, where we look at median house price to earnings ratio, 11.87 of earnings, earnings to median house price, the highest in Essex.
Yep.
And obviously a marked change from 1997. Someone who had their children in 1997 or, bought their house in 1997 and had children thereafter, they would have paid 4.2 times if they were on the median basis, and now their children will be looking for a house and be looking at near 12 times. We see you draw out in the paragraph there that one effect of this is that more people are finding themselves not able to afford to continue to live in this district. What do you say in terms of, the social consequences of this position?
Yeah, this is a real problem. I mean, this is an area that's very expensive to buy a house. The council's own housing needs assessment described it as a high and unaffordable level at these affordable housing ratios, and they are significantly above national average. And this is bearing in mind that if you want to get a mortgage, they'll often let you out, maybe 4.5 times earnings to borrow for a property, and yet you'd need 11 times earnings to buy a property here. So these are very, very expensive areas to live in, and therefore that speaks directly to the benefit of affordable housing that's coming from this scheme. And I go on at 4.16 to highlight that in empirical terms, the annual affordable housing dwelling need for the council is calculated by the council on their housing needs assessment at 284 dwellings per annum. Well, the local plan is currently planning for overall 310 dwellings per annum. So
Total.
So the actual affordable housing need is, as I've said, is 92% of the development plan annual requirement. Now, of course, that development plan annual requirement is now in itself a dated figure, because we now have the latest calculation of local housing need, which for this district is 586. But the affordable housing level requirement at 284 is still nearly 50% of the new LHN. So, you know, the housing numbers have got up, but the affordable housing requirement is a significant proportion of the overall housing need.
Okay. And then in terms of actual delivery, we know where we are now. Let's look at delivery. 419. You've done a little work there to look at what the actual delivery of affordable housing has been since the start of the development plan period.
Yeah. And I think the upshot of it is my conclusion is there needs to be a major increase in housing, affordable housing delivery in order to meet needs, and I think that's pretty evident and borne out by the figures that I've put in the evidence.
Yeah. So at 420, you tell us number of affordable homes over 10 years is 615 of the 3,084 total numbers of dwellings completed over this same period.
Correct.
Therefore, of the dwellings delivered, the affordable provision has been 20%.
Yes.
Yeah. What do you say to the point by Mr. McGarrity that, well, I'm going to have to temper the weight that I give to affordable housing because it's only policy compliant of 30% and not more than the policy compliant figure in the context of those statistics and figures that we've just discussed?
Yeah, so there are often schemes that are 100% affordable that come forward, but there are often, more often than not, the majority of affordable housing is often provided through Section 106 obligations aligned to market housing schemes. And if you see those figures, you know, the average delivery is about 20% of the overall housing delivery in the district. So provision on one single site of 30%, you know, books that trend of a figure that's normally much lower in terms of delivery of the affordable housing overall comparative to the market delivery. So it does show that, I think that potentially shows that not all schemes will deliver 30% affordable housing, because if they did, it'd obviously be a much higher figure and a much higher proportion of the overall housing delivery in the district. And that probably speaks to issues about viability, but also some sites which don't necessarily qualify for affordable housing as well.
Okay, thank you. In terms of other benefits, there was some discussion with Mr. McGarrity this morning about whether something that is something that's required as a result of the scheme. The example there was public transport contributions.
Yeah.
We explored public open space, which again is a policy requirement. Biodiversity gain is needed when you provide development. There's a legal requirement for that. What's your view on, depending on the particular circumstances of what it is, how do you approach whether that is mitigation only, if I put it that way, or mitigation which also provides a wider benefit? And if it's the latter, what do you do with it?
Well, again, I don't accept the way that the council's witness seem to propose their view there. I mean, essentially, you can have different elements of benefits that may well be mitigations for your development, but and obviously you need to be conscious of the requirement that it's not for developments to solve existing problems. It's for a development to mitigate its own impact. So I get that point, that said, you're dealing with mitigators to deal with the impact of your development. However, consequently from those improvements, they can have wider benefits, and those can often be weighed in the planning balance. And I do that with the public open space. You know, we're not only giving tickets to the residents of this scheme to go into the public open space. All the residents can. We've got a permissive path that's going to be created with a medium distance, dog walking route, and anybody will be able to use that, and I weigh that in the balance. And I've got some sympathy for the approach that you were describing and putting to the witness about improvements to bus services. Again, it's not an improvement to a bus service that says, right, we'll put on an extra bus, but it's only for the residents of this scheme. Anybody could get on that bus. In the same way as some tactile paving improvements and improvements to pedestrian connectivity from this site into the centre, where we're putting some drop curbs and enhancing the pedestrian route into the centre, that will benefit other people who are also walking down Queensborough Road. Now, I've not particularly weighed those in the balance. Could have attributed some additional modest weight for those as well, but the principle of adding something in that's beyond the mitigation as a modest benefit I don't think is unreasonable.
Okay. Briefly, obviously, there's a disagreement on the level to be attributed to BNG and also to economic benefits. The point, as I understood it from the council, in relation to BNG as well, that's just a bit more than what the legal requirement is. In terms of economic benefits, well, these are just the kind of benefits you do get from a housing scheme. Therefore, that must somehow moderate the amount of weight that I give to the value of the contribution to the economy, the value of the jobs that are created. What do you say to that approach?
Well, obviously the benefits don't arise unless the development takes place. So they do come out of the fact that this development would be approved and would be pursued to deliver those benefits. And where the council are not delivering the minimum housing land supply, these are benefits that the council are missing out on. The economic benefits of housing delivery, that the government has specifically linked economic growth to the house building industry, where the council are not delivering on their required minimum housing land supply, they're missing out, and this community is missing out on those economic benefits. So yes, there could be the same benefits that would arise from a development in another place, but that doesn't diminish it if you've provided them in this location. That's a benefit to this community, and they should be benefiting from the development in the same way.
Thank you, Mr. Tate. We began at the end. We've already done your planning balance. We don't need to do it again. Is there anything else that you would like to tell the inspector before you answer questions from the council?
No, there was only one question you mentioned the other day, sir, which was about a gate. Do you remember the gate on the development framework plan? Yeah. As I understand, we don't own that route through, and we're not quite certain of the ownership. I don't think. So whilst it's a lock gate, we I think on the development framework reflected the potential future opportunity for that to be a route, but we can't deliver that route through that land. So I wouldn't regard that as a pedestrian connection if you were giving it any consideration.
Yeah, so disregard the star on the framework.
You can regard the SCAR as a potential future connection if that gate was opened and the owner of that side wanted to let it open, but we can't guarantee that, so I wouldn't give it any particular weight.
Okay.
Yeah.
Okay.
Albeit the star identifies the connection from the site into the wider footpath network in the same location.
It does, but you have no control over it. So
no, we have no control of if you wanted to turn left as you leave the site to go through the gate. Yeah. But the star does connect into
the western footpath.
The western footpaths. So you can, you can walk as you can at the minute.
Oh, yeah,
so
sure. Okay. All right. Is that it?
That's it. Thank you very much, sir.
40 minutes, bang on.
Well, I'll try my best.
Yeah, very good. Yeah, okay. Yes, over to you, Miss. I mean, do you need a break?
I'm fine, sir. Absolutely fine, yeah.
Right. Good afternoon, Mr. Tate.
Good afternoon.
let's start with the development plan, please. Helpfully, I think we're agreed broadly on what the relevant policies are. You referred in chief to the most important policies that you identify as S1, S2 and S8, but quite rightly say there's also a longer list of relevant policies at your 3.4, 3.4 of your proof.
Yes.
And I don't think there's anything between you and Mr. McGarity on those, save that you do refer in that list to H4, but then I think later in your proof you suggest that it might not be applicable because it relates to smaller scale development.
Sorry, what paragraph was it again?
I sort of didn't go paragraph, and let me just find it.
Sorry, you mentioned...
It's actually a footnote. It's footnote 22 of Mr. Tate's proof. Talks about, it's on page 27 of the PDF, 25 of the hard copy. Refers to policy H4 and says that it appears more aimed at development control matters associated with much smaller scale developments. Are you saying that policy is not relevant, therefore, or?
Obviously, I was at the time of writing that trying to understand the council's statement of the case, and obviously it was a policy that was referred to in the decision notice. So I needed to go to the policy and understand what potentially the council was saying was the conflict with that policy. And when you go to that policy, obviously it's got a series of headings to it.
Let's just go to it then. Let's have the inspectors. Page 88.
Page 88, yeah. So my comment was the policy generally in some parts seems to relate to smaller, more development control type matters. So the density bit is the first bit, but then the other aspects of the policy that are on 89 relates to alterations, extensions and additions. That's like to a building, I presume. And then replacement dwellings, that's the sort of smaller thing. And then backland and infill development, again, so, and then extension to residential curtilage. So, and where the council sort of cite in their decision notice conflict with H4, and I couldn't really work out from the council state. I didn't know which part of the policy you were sort of suggesting we had a conflict with, so I'm trying to guess what it is. So when I was guessing what it was, I was thinking it must be then for just this first bit about density that says all development will be design led. Well, we aren't design led. Seek to optimise the use of land, having regard to optimise the use of land. So I don't think we're underusing the land. The following considerations, and then if you go for each of those following considerations, and I sort of took the view that I don't think we conflict with it.
Okay, but you accept that first bit, the density bit, does apply to all development.
That's the bit that I assumed the council were, if they were relying on anything this policy, it must be the bit about density.
And I think
that we're not using effective use of land because we're not dense enough.
Unfortunately, I'm not going to. Let me just get
or
the
are we
decision.
Too dense?
The decision letter up. Sorry, wrong one. CD 5.2.
It's refusal reason 1, isn't it?
Refusal reason 1. Yeah, that's what I was just checking, sir.
Yeah.
Treat to S1, S8, D1 and H4. Yeah.
So there's no dispute between us that first bit is applicable here. And in terms of what Mr. McGarity, well, it's applicable. Whether it's breached or not is obviously different, but that it applies to all development.
Yes, I think yes. I think if that's the question, does that first bit apply to all development? Yes, it does.
Yeah.
So that it must be that bit. So my point was, it can't be the rest of the policy because they're all peripheral bits to do with other types of things that we're not. So it must be that density bit. But what I couldn't work out from the council's reading for review, it just says H4, and therefore, if it is the first bit, it doesn't even say H4 part whatever.
Yeah,
you know,
I don't think any of, to be fair, I don't think it gives sub-paragraphs for any of the
which
policies
is-
referred
and
to.
that's
in the
part of
reasons
the
for refusal.
issue. That it's very hard to understand why we were, and that's why we're asking for
Okay.
clarifications on the council's statement of the case, because it was very difficult to understand what the actual planning harm against policy H4 the council was suggesting. I'm still not quite sure because I can't see a conflict with that aspect.
In terms of, well, yes, okay, but we're agreed that first bit in theory applies. Whether or not there's a conflict won't come on to. We agree that the most important policies in the plan are deemed out of date by footnote 8 of the MPPF because of the housing land supply position. But we also agree, and I think you've helpfully confirmed this in your answers in chief, that you don't discount those policies completely, do you?
Of course not.
You have to consider their consistency with the MPPF and then decide what weight you attribute to any conflict with those policies.
Well, the development plan is still the starting point for any decision, so we have to start with that and then consider what weight we apply to those policies.
Thank you. And on that basis, in terms of the weight that you give to any of the policies, I think there's broad agreement between you and Mr. McGarity, save in respect for policy S8, which I will come back to, where I think is the main one where you disagree as to its consistency with the MPPF.
I disagree on S8, yes, because that's the one.
That's the protect the
consistency,
countryside.
The consistency point. There's obviously a subtle difference in terms of S1, in terms of the tilted balance and the approach that's taken in that one. But yes, yeah, that's correct.
Well, yes, and I was about to come on to S1. So, I mean, you agree that it's broadly consistent with the MPPF. There's some change, there's some differences in the wording, but do you say that those are material in this case?
Well, you can have a big debate about whether or not relevant or important policies. If you say the way that's, and this was one of the changes in the NPPF that came out, it changed it to most important policies, because the way it was previously written, it was all relevant policies are out of date. Well, that would be all the policies, wouldn't it, that were relevant? It didn't really seem to make sense before, so they narrowed it to say the most important policies. This one now says the relevant policies are out of date, so
Okay.
you could have H4 and say that's out of date
Yes.
against this policy. So there are, but in terms of its approach that says where you've got circumstances of situations being out of date, apply a tilted balance in forming a judgment to see if you can actually try and grant planning permission to solve the problem with policy being out of date. I mean, that's what it's trying to do in the same way as the framework's trying to do it. So in principle, it's trying to do the same thing.
Yeah. In terms of a determinative test for this appeal, that if you apply policy S1 or the MPPF, we get to the same broad test, which is, do the adverse impacts significantly and demonstrably outweigh the benefits?
We do.
And those adverse impacts will include all sorts of things, but conflict with development plan policies and any MPPF policies will amount to adverse impacts that have to be weighed in the balance.
Yeah, there's a planning harm associated with it. Yeah.
And then in terms of that planning balancing exercise, the disagreement between you and Mr. McGarity boils down to the weight that you attribute to the various benefits and harms, and then how you answer that determinative question of whether the harms significantly and demonstrably outweigh the benefits. That's the dispute between you.
Yeah, it is. Council's planning witness is doing a planning balance, and I'm doing one, and the inspector will do his own planning balance against his judgments on what he thinks the way to do those. I can only say what my opinion is, and the inspector will no doubt have his own.
And you've sort of foreseen my question that those are quintessential matters of planning judgment, aren't they?
Of course they are. Absolutely, yeah. But they need to be sort of have some reasoning around them, don't they? So, hence why Mr. Hawley was testing your witness as to the reasoning behind the judgments that have been made.
Yes. Test that reasoning, but there is a question on which reasonable professional witnesses can reach different views.
Yes, on reasonable judgments of evidence that's in front of them. As long as they're acting reasonably, then, and they're looking at the evidence properly, then you'd be surprised if there was substantial difference in judgments, but there can be different subtle differences in judgments, yes.
let's start with landscape then, in terms of the adverse effects that need to feed into that balance. We've had the roundtable session, there's been a discussion about it more today. Dispute between the experts is ultimately a relatively narrow one, which also turns on questions of professional judgment, doesn't it?
Yes, and in reality, those two witnesses are very closely aligned in terms of professional judgment on landscape impact. Not entirely dissimilar to Mr. Drummond, who obviously looked at it for the council at the application stage as well. The
crux of a dispute between those witnesses is, there are some other small points of dispute, but the crux of a dispute is what the residual landscape impacts will be at 15 years.
Yes.
And there's no dispute, but there will be some landscape harm. Again, you covered that already in chief. The issue is what level that harm will be, and therefore but as between you and Mr. McGarity, what weight you attribute to that harm in the planning balance.
Yes.
Now, your assessment of weight, which you've given to this, is based on Mr. Holliday's evidence. Is that right?
Yes, and I mentioned in my my proof that I obviously highlight the views of the council's own consultee in terms of forming that judgment as well.
I appreciate that you say that there's not a huge amount of difference between the two experts, but if the inspector were to prefer Mr. Friend's assessment, obviously the greater the harm that the inspector finds to landscape, the greater the weight that will be attributed in his planning balance.
Yes, absolutely. Yes, if there was a great deal of landscape harm, then you would weigh that heavier in the planning balance. But in this case, the harms are relatively moderate, even by the difference in view at a higher level by the council's own witness compared to Mr. Drummond and compared to the appellants. So none of them are particularly saying major adverse impacts at the 15-year stage. So that's why I think it's with some legitimacy that it doesn't seem to align to the evidence of the weight that the planning witness for the council has been putting on the landscape harms.
I mean, is it fair to say that it's a sliding scale? That we're not got buckets of which there's no hard and fast rule that you have to have a major adverse harm in landscape terms in order for it to be significant in the planning balance. That's a matter of judgment, isn't it?
Well, it's all a matter of judgment, isn't it? But I find it hard to reconcile without some major landscape adverse effects how you could then translate that into significant landscape harm. I mean,
I appreciate that's what you're saying,
and that's what I'm saying. And the council's witness has conflated the two into a position of significant landscape harm. And my own view is I think that's over egging the harm that's suggested. And again, I don't think that's consistent with our evidence on landscape or indeed the council's consultant at the application stage.
Sorry, you don't see how modest harm could possibly have significant weight.
What I was saying was I don't see how moderate landscape and visual impacts, which have been described in the assessment, could translate into significant planning harms in landscape and visual terms.
Yeah.
I think if you were getting up to those significant landscape implications and substantial landscape implications in the planning balance, you would need to have some major adverse landscape impacts to be assessed at year 15 to come to those sort of conclusions in the planning balance. And obviously there was a lot of discussion earlier on, sir, about the Taylor Wimpey or the home farm scheme relatively near to the site. But of course, in the descriptions and the assessment that was done for that, the terminology in the assessment was seeing significant and substantial landscape and visual effects, and therefore would get to a level that you would put substantial landscape adverse impact into the planning balance.
Yeah, I understand. Yeah.
I mean, I think it's fair to say that in Homefield there's no dispute between us that there were higher levels of landscape impact found, but equally the inspector reached a much higher level of harm than what Mr. McGarity is arguing for here. I think they reached very substantial weight to the landscape harm in the planning balance. Is that right?
Yeah, I mean, I think so. In terms of, I mean, there's always a difficulty in terms of looking at two decisions. I mean, you know, each application needs to be determined on its own merits, and it's very difficult to look at two different cases. We talked earlier on about we don't know what that planning balance scale was that inspector was dealing with, and had a slightly different scalings and weighting, different tiers of weighting. And we don't know what evidence was in front of that inspector, but there's some relevance to look at that one. I mean, you know, the concern I had in looking at the council's evidence was that I think too much reliance was placed on that as a reason to elevate the potential planning harm in landscape terms, than actually is reasonable to do so, because I think it's quite a different site of quite a different scale in a different location, that has clearly quite different landscape and visual effects that were assessed.
Okay, so dispute between you as to, dispute between the experts as to the level of landscape harm, dispute between you and Mr. McGarity as to the weight you give that in the planning balance. Also a dispute, I think, there is a dispute between you and Mr. McGarity as to the policy implications of the landscape harm, or perhaps more accurately, the weight to the policy implications, because I think you agree that there's a breach of policy S8.
Yes.
But you say it's out of date and inconsistent with the MPPF because it seeks to protect the countryside. It's that word "protect," I think, really is the crux of the dispute here as to whether it's consistent with the MPPF or not.
Yeah, I think that's the crux of that. If you were seeking to protect the countryside, then you know, we are in direct conflict with that approach. And I couldn't get over that bar if it's all about protection. So I can't get past go. Whereas if I'm recognising it, I can put it in the overall planning balance, noting that the policy's out of date and it's constraining housing delivery, and that's why, even if there is a conflict with it, I only give that limited weight.
I mean, this isn't a policy that is just seeking to protect the countryside for the countryside's sake, is it? I mean, it does reference the particular aspects of the countryside that the MPPF is also recognising.
Yes.
Yes, I mean, we can turn it up if you want. I think we're all very familiar with it now. But landscape, natural resources, intrinsic character and beauty, that's all reflecting the MPPF para 187B. Yes. But the issue that you say is that it says protect, whereas 187B says recognise.
Yeah, and as I say...
So 187C, sorry. B, it is B. Oh, thank you. Yeah. Doubting myself.
B,
Thank you.
As I say, if you retain that word protect and you apply it with full rigour, we're going to be in a difficult position to resolve the housing supply issues.
I suppose that's if you say that protect means don't build anything on the countryside. I mean, there is some. I appreciate what you say, that the MPPF uses the word recognise, not protect, and what Mr. Hawley put in cross-examination, that other places in the MPPF it says protect, and so therefore there must be a difference between the two. I'll admit, what do you say in practice is the difference between the two?
In practice?
Yes.
What's the difference between the word protect and recognise?
Well, in terms of what it means when you're considering the acceptability of a development on a piece of open countryside.
Well, if you were considering a development on a piece of open countryside against a policy that was protecting that countryside, you wouldn't be building on it.
So you say protect means don't build at all?
Yeah.
Whereas recognise means
recognise we need to make a balance and judgment about its value in those terms, but it's not saying thou shalt not build on the countryside, because if we were saying that, and that was national policy, do not build on the countryside, protect it, then we're going to struggle to meet the wider objectives within the framework, which also say we have to meet the full housing needs.
I understand that, but just as a...
We still need to recognise, and that's not diminishing its importance, to look at it and be careful in terms of considering it and recognising its importance and beauty. And I am weighing that in the balance.
Okay, so you're weighing it in the balance of the wider need for housing, the lack of a 5-year housing land supply, but just, I mean, sorry,
No, carry on, sir.
you were probably going to ask this, but how can the development of an agricultural field, a green field used for agriculture, recognise the intrinsic beauty? Recognise the intrinsic character and beauty of the countryside. How can building a suburban housing estate on a field recognise that?
Yes. Well, it's going to have to do it in an overall planning and balancing exercise that says, well, we would like to, if we can, recognise the character and beauty of the countryside, but we've got competing requirements for elements of development and meeting needs. So whilst recognising that, we need to balance it. Now, if the housing needs were being met, then in recognising that value and character and intrinsic value of the countryside, you wouldn't build on it because the housing needs are already being met. So you are recognising it by not building on it if there were other circumstances that were not requiring you to. So it's about recognising. Whereas if you don't have that recognising, you don't have that in, to apply a balance across those competing elements, and you have a protection, say like in a local green space, protect a local green space or protect, valued landscape, then the word protect in those circumstances is quite key in decisions that relate to valued landscape, that mean that the test and the approach in the decision making is substantially different. So I think.
Okay. Fine.
And so, insofar as this policy is seeking to protect, not in the sense of saying, and I appreciate that it goes on to say outside of defined settlement boundaries, planning permission will only be granted in specific circumstances which we don't meet, and Mr. McGarity accepts that part of the policy is out of date in terms of preventing development outside of settlement boundaries. But in terms of the policy seeking effectively to recognise landscape harms and weigh that in, if the policy is trying to say that landscape harms need to be weighed in the balance, there's no issue with that. That is consistent with the MPPF. Yeah. It comes down to a question of interpretation, which that's for submissions. I can, fine. Okay, so the issue where you say this is inconsistent, it's to the extent it says do not build on the countryside. Yes. Fine. Now, Mr. McGarity says that there's also conflict with policy D1 as a result of the landscape harm. Do you agree, disagree with that? It's page 48 of the plan. I think you pointed in particular to it's 1C of that policy.
Yeah, so again, D1's referred to in the council's reason for refusal, but of course there's 2 sections of which there's parts A to G. Well, no, there's 10 sections. The point being is I didn't know which bit the council were relying on to say the conflict was there, because it surely can't be all of it, but is it to my understanding that the council are saying, I can't ask you a question, but my understanding is the council are saying that we do conflict because where the policy says developments must respect and enhance the character and local context and make a positive contribution in terms of landscape setting, townscape setting and skylines.
Yeah.
that the bit the council are
Right, so
concerned
yes.
about?
That's one part. There's another part in relation to amenity, which we can come on
Provide
to.
sufficient and usable private and public amenity spaces.
Sorry, no, number 4, protect the amenity of surrounding areas taking into account, but that's relation to a different harm, which we're not talking about now. But just in
Okay.
terms of 1C,
Yeah.
that is a concern that the council has identified. Do you agree or disagree that there's a conflict with that aspect?
Well, I don't think there necessarily is. I mean, I think that, if the council are, indeed, even in their local plan as they produce it in the future, allocate sites for development and bring development forward, they will still want to bring development forward that's sensitive to the landscape setting and skylines of towns and villages, etc., etc. And we're bringing a development forward that is sensitive to the landscape setting of Southminster. I think it respects it. Would it enhance the character and local context? I think it will.
You think it will enhance? It will enhance the landscape
this could be
setting.
a fantastic development. A beautiful housing development with extensive green infrastructure, local open space, areas for biodiversity, sensitive landscape setting on the edge, green landscaped areas that soften the edge, assimilates into the settlement form very well, has limited landscape impact. Yeah, I think it would contribute locally.
And you heard Mr. Friend's evidence at the round table session that, in his view, the mitigation design or the planting won't be entirely effective because of the topography of the site and where the open space is by reference to the built form. Do you remember that evidence?
I don't particularly recall that bit now.
So I mean, the point that he's making is that the open space and the planting that is designed to mitigate the landscape harm is on the lower portion of the site, the northern edge of the site, which is lower than the southern part of the site, and therefore it's not going to hide the housing.
Well, I don't think necessarily settlements and character of settlements need to just hide development. If it's a high quality housing development of attractive and beautiful houses set within a nice landscape setting with green space and green infrastructure and areas managed for biodiversity and etc. This could be a very attractive and contribute positively to the local settlement.
Okay, so your view, your position is that we've currently got a green field. And the setting is it's a green field. Yes, okay, it's settlement edge location, but there's also fields on 3 sides. Not quite 3 sides, but it's a settlement edge location. So there is settlement on one side, but there's also open rural countryside on other sides. Your view is that putting housing onto that site is going to not only just respect, but it will also enhance the landscape setting. That's the evidence that you're giving.
Well, it talks about respect and enhance the character and local context. The local context is not just the wider landscape, but it's obviously the settlement and the settlement edge. So there is built context to this site as well. And it assimilates into the local landscape setting. So there are contributions it can make. I don't see an inherent direct conflict with that policy, particularly in terms of the quality and the way the scheme's been designed and set out within the design and access statement.
In terms of amenity impacts, again, we've heard specialist evidence on the noise point, which I'm not going to go back over. One point that you made in chief about the various permutations of the internal access road. Obviously, Wardell Armstrong, when they submitted their noise screening assessment, had modelled based on a particular layout. That's what the EHO then went on to consider. And if we can just turn up the EHO response, it's CD 3.14.
Yeah.
have to check the inspector's got there.
Yeah.
Okay,
Oh,
so
oh no, it won't. Can't.
yeah, I was having that problem with it.
No, it won't let me read that.
So, we don't have a hard copy. Do you have access to the core documents online at all, sir, or just the...
Sorry, where else would that? I'm trying to think where else they'd be. So there was a link to the. Hang on, there's a link to the website. Yeah, yeah. So
I seem to be able to open it online, but not download it for some reason that I can't understand.
Oh no, that's what I've got. No, I didn't save it because it. So where is it? Where's the link on the council's website?
Oh, you have to go through the planning portal and put in the application. I mean,
All I've got is my SharePoint link.
okay.
I've got a copy of it if you want to.
Yeah. Okay. Yeah.
Is everything else closed on?
I will make sure that.
Sorry, it's a very short point for the level.
Well, do you, yeah. If I can see it on. Can you see it? Then?
I've got it, yes, but I've had to save it through a different.
Yeah. So yeah.
Okay, so short document, no paragraph numbers, but you can see that under noise there are 3 paragraphs.
3D 3.14. Yeah.
3.14.
And under noise.
Under noise, and it's the 3rd paragraph. So the principal area of concern is the new access to the site and its proximity. Well, first, sorry, let's just start with under noise. I've reviewed the Wardell Armstrong screening letter. That's the letter that we've been considering in relation to the noise experts. And then in the 3rd paragraph, the principal area of concern is the new access to the site and its proximity to 48 Queenborough Road. From an acoustics design point of view, the site access is not ideal as it brings a new source of noise close to the nearest noise-sensitive receptor. I am assured that there are other significant constraints around the existing access track for the builder's yard which is to be retained. These mean that there is no viable, better alternative layout from a noise point of view. Has that position changed?
Well, yes, we submitted with our statement of case a couple of other designs that have alternative alignments of the road.
I appreciate that there are other alternative designs put forwards, but the EHO was under the impression that they were not viable. Are they now viable?
Yes, those were alternatives that were put forward. I mean that was sort of subsequent to this comment that was raised. So that there are alternatives. So you had that view then.
Alternative trackings of the access road.
Yeah.
Okay, fine. And so it was the case. It's just the position's moved on since the EHO considered.
Yeah.
Fine.
And in reality, obviously, at that point in time, the EHO was saying, even with that situation, he was still happy and content. But then pointed out, it's not ideal. It'd be better if the road was a bit further away. In which case, we're saying it could be because we've submitted a couple of designs that show an alternative.
Sorry, where does he say he was very happy with it?
Well, he says, I'm satisfied. This is the 2nd paragraph. I'm satisfied that there is unlikely to be any significant adverse impact from noise on the future occupiers of the site, and I've no further comments in our respect.
Okay,
yeah.
He says the principal area of concern is the new access. And it says from an acoustic planning point of view, the site access is not ideal. It brings the noise source closer to the nearest nearest noise receptor. But he didn't think that it could be moved, so he assessed it on that basis and was happy.
Yeah, but, I mean, to be fair, that 2nd paragraph is dealing with the amenity impacts for the future occupiers of the site, but except that the EHO ultimately didn't believe there were reasonable grounds for objection based on noise impacts on number 48 either. That's the conclusion he comes to over the page on, or he or she, I'm not sure who it was, on page 2.
Yeah.
And
Sorry, where is it on page 2?
On page 2, 2nd paragraph. The reliance on closed windows to achieve the recommended nighttime guideline levels is not ideal, and the council would always prefer for guideline levels to be achieved with partially open windows. but BS 8233 does allow for assessment with windows in the closed position, and I therefore do not believe, or I suppose do no believe, that there are reasonable grounds for objection based on noise impacts.
Oh, so the EHO said that basically no objection because the windows could be shut.
Yes, and that was the issue that members took, and you heard from Mr. Aguilar also.
Oh, right. Okay.
And that's obviously where things have moved on. We've now got different noise evidence in front of the inspector that has considered windows open, and also the northern facade, because the Wardell Armstrong report did not consider the northern facade, and that's what the EHO was considering.
Sorry, just to make,
Yeah.
just in terms of context and the reliance on closed windows, that was in terms of the assessment on the western.
Yes.
And it is going to agree that those windows can be closed.
Oh, right,
The
yeah.
noise environment is such that the windows will be closed anyway.
In any event.
The point is that the EHO didn't at any point say, oh, you need to assess the
Northern facade.
as well. Obviously, the council now say, well, you
Ah,
need to
right.
assess the
Yes,
northern
yes.
facade. That's the point. The EHO was content, hence the reason the appellants stopped where they did, because why would you carry on assessing and submitting things when the EHO has said your assessment is satisfactory, I don't require anything further, I have no objection. But in terms of those closed windows or partially open windows, that was on the western side, so nothing has changed there. And we disagree that that's fine.
Okay. Fine. Yeah, okay.
And ultimately, so that's why we're reacting to this additional issue about the northern facade, because obviously that's now been raised. In the
Sorry,
evidence of the
I haven't
council.
read that, partly because, well, I couldn't see it. So, yes, I've now seen it.
We'll make sure that a PDF is sent to your case officer that, so that
Yes,
you can
please.
have
Yeah,
it.
Yeah, please do that, because I'll need to see
Yeah.
that, and it needs to be put on there. So, yeah.
Okay, in terms of the impacts to number 48, there's no dispute in principle that the impact on one house can be a material consideration. It's not your case that because it's just one house we can ignore any impact.
No,
No. That might be relevant to what weight we ultimately give to that harm.
I heard what the council's witness says that. That's why he's tempted to just stay,
Exactly.
moderate level.
That harm is relevant to compliance with policy D1, and we looked at that point about amenity, but we can just go back to it if that's. But policy D1 requires development to protect the amenity of surrounding areas.
Yes.
Yeah.
Yep.
So any harm to number 48 is relevant to compliance with that policy, and also with the MPPF paragraph 198A.
Correct.
Policy D1 is the policy that you accept can be attributed full weight.
I don't suggest there's any conflict with the framework or
Yeah.
any inconsistency.
So yes.
Yes.
And the question of whether there's conflict with that policy will ultimately depend on the inspector's view of the noise evidence that he heard yesterday.
Correct.
In terms of the acoustic fence,
Sorry, if I could just add, and obviously having regard to consideration of the mitigations that could be in place through reserve matters that deal with the layout and the planning condition that would deal with matters at a later stage.
yeah, okay.
To the extent at which he can make a judgment at this outline stage.
Now, it's been said several times today that you are proposing a 1.8 metre high fence. I appreciate that the evidence is based around there being a 1.8 metre high fence, but just from a very technical point, there is nothing in the plans that are going to be secured by this outline permission, the conditioned plans, or even in the condition, and even in the updated draft condition, which I've now had sight of, that fixes this as a 1.8 metre high fence, is there?
No, I don't think there is. And in reality, the condition specifically requires the details to be submitted. So,
Yeah.
so it could be something. It could be something different. But I think obviously the context of where that initially the requirement for that fence came was, again, in that response, I think it was in the response again.
It was from the EHO. And
the EHO said, well, there is a fence already there. It's at 1.8 metres high. So it says, if the existing 1.8 metre high fence is retained and runs the entire length of the boundary, meets certain specifications in terms of surface density, lack of gaps and holes, etc. However, it says to ensure appropriate external knobs, it might be prudent to secure a condition, an acoustic fence barrier along the boundary which meets the necessary specifications, rather than relying on the existing fence over which the applicant may have no control. So the point was, I think, there's an existing 1.8 metre high fence that was having an effect on screen noise, but obviously it might get a hole in it, it might, the owner might take it down.
Might take it down, yeah.
Exactly. So it was the EHO saying, well, I think we should, to make sure certainty that there is going to be a barrier along this road as currently proposed and aligned at that time, then let's condition the details of a fence to be submitted. Now, it could have been, we're not asking this inspector to approve a 1.9 metre fence, but that was the context in which it was suggested. But I don't know how that, obviously I don't know then how it translated into being a 2.5.
Well, we don't know that. And we don't have any, I mean, Mr. McGarity has given his report of what's been told to him, but we don't have any evidence before in writing
reality,
as to what.
1.8, what I said in my evidence is you can put a 2 metre high fence up under PD rights, and a 2.5 metre is only 50 centimetres higher. So, I mean, what I was struggling to understand was how you get sort of substantial, impacts to Queensborough Road in terms of a visual impact from a fence as such that would warrant refusal of planning permission just on that issue alone.
But ultimately, just as again a matter of fact, the condition that we've got, the draft condition that the inspector's seen, but equally the revised draft, there is nothing in that which fixes the height of the fence, is there?
No.
And there is nothing in that which says that it's only mitigating the harm to the ground floor and the garden. And in fact, in the revised draft, it's trying to mitigate the harm to the first floor windows as well.
So this has come out, and it's the council's concern on the council's basis that of their assessment that the first floor window would still have an adverse effect. That has only transpired in terms of the evidence that the council have eventually pulled together in terms of this inquiry. We were seeking to understand what the council's concerns were in respect of noise for an awful long period of time before evidence was submitted, but here we are. So even as the local plan says, and the MPPF says, we should be looking for solutions to deal with matters like that, and the one way of dealing with it is a planning condition that can ensure that the noise and amenity of that property can be protected.
If Mr. Bryant's if the inspector accepts Mr. Bryant's evidence to the level of impact to the first floor window, a fence to mitigate that impact, he said, and I said, and I don't think Mr. Healy disagreed, would potentially have to be higher than 1.8 metres.
I didn't hear it on that basis. My understanding of it was there are various different factors that would play into the assessment of how the noise would affect the first floor window. If the road was brought further away,
if the road
was brought further away, it would have the potential for significant changes in the noise environment for that property. I think it was the suggestion like double the distance, half the noise. But there was, and obviously moving the fence closer to the noise source, etc., etc. So, I mean, I think even in fairness to your witness, I think I don't think he was in any way dissuaded that a solution couldn't be found at that stage. But obviously, it would be subject to the detailed submissions that would need to be made in the acoustic assessments that the condition requires. So, that was a proactive and positive approach to try and deal with that concern that still remains with the council, if the inspector retains the concerns on the levels of noise that the council are predicting.
very briefly on heritage, because I don't think there's very much in dispute, well, if anything in dispute here in terms of the approach. Paragraph 215 of the MPPF requires a balance of the heritage, less than substantial heritage harm against the public benefits, but that doesn't then avoid the need to weigh heritage harm in the overall planning balance, does it?
And I do that.
Which you do. And then we've got the point that the inspector raised, where you've got the section 66 of the Listed Building Act, which tells you to give special regard to the desirability of preserving the setting of a listed building, and paragraph 212 of the MPPF, which says to give great weight to the conservation of a heritage asset. Albeit neither of those necessarily tell you what weight to give to it in the planning balance, do they?
No. And I did understand the inspector's question about that, and how you reconcile the two. But it is quite commonplace, and I've given evidence at a number of inquiries where, you know, we still give considerable importance and weight in the context of the statutory duty for heritage assets, but can take a judgment as to the planning weight that weighs in the balance, particularly where impacts are not on the actual building itself, but maybe on the setting. They're less than substantial, and in this case, as we know, the very bottom end of that less than substantial scale. So I still think you can give the matter considerable weight and importance, but then still form a judgment that it's limited weight in the planning balance.
And actually, I don't understand there to be a dispute between you on that, given the evidence that was given this morning. So let's move on. Market housing as a benefit, there is a dispute between you in terms of weight to give to that. Do you accept that in principle, the level of housing land supply shortfall is relevant to the weight attributable to the provision of housing as a benefit?
Yes, if it was just a marginal shortfall, then you might well give it less. But
the greater the shortfall, the greater the weight, and the converse is true. The lower the smaller the shortfall, the less the weight.
Yes, yeah. In some broad terms, albeit, you know, you get to a certain level, as we are here, where, you know, the shortfall is significant, and in that context, the sort of the debate goes really. You know, once you're into sort of significant levels of shortfall, even more significant, even greater significant, yes, you do get to that. You do get to even more weight, but it's sort of. I don't think. Well, the main point is I don't think we're in any way in a position where it's a marginal shortfall in this case. I think it's a significant shortfall, and there should be significant weight to the delivery of.
But obviously, I mean, there are authorities which have a 1 point something year supply. We're not in that category either.
Yeah, and again, the issue about, you know, 1.1 year supply obviously also speaks to issues about what the annual requirement as well is. So if you had a very small annual requirement, that might only be a small deficit. If you had a significant annual requirement of many thousand houses, then that deficit would be. So it's nuanced to each case. But my view on this one is we're not anywhere near a marginal shortfall that would diminish the substantial weight.
So you say there's a level of shortfall that you get to where it gets substantial weight, and anything below that is also substantial weight. There's sort of whereabouts is that at? We're obviously between 3.6 and 4.4 years.
I think you need to form a judgment on each case, don't you? So in different circumstances, you might give slightly less weight, but in theoretical circumstances, it's very difficult for me to sort of predict. But in this case, on my judgment, given the extent of the shortfall, including by Mr. Pycroft and by the council, the shortfall is significant.
Okay. No dispute that in principle the extent of the shortfall is a relevant factor in determining the weight to give
No,
to the
no, as I've said.
And in terms of affordable housing, again, no dispute between us that what's being provided is the policy compliant 30%. Yeah,
The provision of affordable housing is policy compliant at 30%, yes.
yeah, which equates to 33 houses.
Up to, yeah.
Up to, yes, of course. And again, in principle, do you agree that the provision of affordable housing beyond the policy requirement is something that to which can be given greater weight than one which meets policy?
Yeah, it can do in certain circumstances, yes.
If you've got a 100% affordable housing scheme, that's going to
Potentially
be...
could be, depending on what the need is. You could have 100% affordable housing in an area where they've got plenty of affordable housing, and you might not get the same credit for it in an area that hasn't.
Okay. In this authority and the situation that we're in, a scheme that had 100% affordable housing would merit greater weight than the scheme that's before the inspector.
Yes, it may well do, depending on the location.
And
within the
you've...
district.
Sorry, Carol.
No, that's it.
But you've given the scheme the highest, the provision of affordable housing the highest weighting on your scale, correct? There's nowhere else to go beyond substantial.
I have given it the highest weighting,
Yeah.
Because there's a variety of different factors that I've pointed to that point
Yeah.
to the benefit of the affordable housing in this case, not just the percentage.
Yeah, a variety of factors which go to it being a benefit, an important benefit, which is recognised. There's no dispute between the two of you on that. I mean, but in terms of the factors that go to the weight, one of those factors is the amount of affordable housing that's being delivered, either in percentage terms or in absolute terms. 100 affordable homes is better than 33 affordable homes.
Yes, although I've got some sympathy for the point about percentages. Percentages doesn't really necessarily tell you the empirical basis of what you're providing as.
Yeah, that's why I asked you about absolute numbers.
Yeah, absolute numbers is important, isn't it? Yeah.
Okay. Economic benefits, again, regardless of the question of weight, it's fair, isn't it, to characterise the benefits that are being provided here as standard benefits which would result from any housing scheme. There's no special benefit that is coming from your scheme outside of what would be delivered by any scheme.
Yeah, the word standard just sounds a bit ordinary, doesn't it? These are just standard benefits. I mean, they're great benefits in terms of the economic benefits, aren't they? Because, we're in a situation where the economy in this country is in need of economic support, and the government are trying to drive economic support. So a sort of, I'm sure you're not saying it like this, but a sort of blasé, these are just standard benefits, I think underplays really where the government are at in terms of linking housing delivery to economic growth. And unemployment rates are rising. The government are all about cost of living and trying to get people in employment and wages, etc. And this is an opportunity for more jobs to be created and investment into the local economy. That money will go into local services and shops and facilities in this settlement. Yeah. And when you have a village location like this, that sort of scale of development could have more of an impact on that village than it might do, say, in Malden, for example. So I think the economic benefits are significant in my view. I mean, again, it's a judgment view. You can form the inspector might form a view that they're not as high as that. But in my view, at this moment in time and in this current economic climate, they are significant benefits that shouldn't be just dismissed as standard benefits that could have come from anywhere.
Yeah, and perhaps the word standard was, not the best chosen word. They're typical benefits that would arise from a housing development. That's not to diminish that they might be important, that they are benefits and they're important and that they will be good things. We're describing them as benefits. There's no dispute between us on that. But they are the typical benefits that will arise from a housing scheme.
Calculate them on a similar basis for similar schemes across the country, with some slight differences in terms of level of expenditure, dependent on different locations. So we do calculate them slightly different, but they are calculated on a similar basis. So yes, the case is, of course, that those benefits don't arise without this development.
Of course.
And of course, if we don't bring this development forward and the council continue not to provide the housing land supply minimum, these benefits just won't arrive.
Yeah, and we wouldn't be talking about them at all if we weren't in that situation. So there's no dispute between us on that. And specifically the benefits we're talking about are construction spend and construction jobs when in building out the development. Then the new residents that will come in will be employed, or a proportion of them will be of working age, and that will generate some benefits. And then council tax contributions. I mean, you set them out at 4.23 and 4.24 of your proof. That's quite a high level summary, but those are the types of economic benefits that we're talking about.
Well, yeah,
yeah.
that's the types of benefits, yeah.
Fine. Public open space, again, we've been to policy D1, but another requirement of it, which we didn't really touch on, but is to provide the public open space, recreation routes and play spaces, correct?
Yes.
And the development framework plan gives an idea of how those would be provided on the site.
Correct.
Albeit not being fixed at this stage, matter for detailed.
General accordance
Well,
with.
there's general accordance with.
Yeah.
There's no fixed amount either required by the policy or, in terms of it all being secured here.
Yeah, I think there's an expectation of a certain level of provision of open space that would be delivered within the scheme.
Okay. I think there's a reference in your proof to 1.9, it's 4.30 of your proof to 1.97 hectares of landscape, green infrastructure, public open space, play and habitat, but obviously that's a lot of different things, not all of which is the public open space provision.
Yes, correct. Yeah, so it's a sort of, I think from the development framework plan, I think it's a sort of green infrastructure calculation of all those different components that would go together. So it represents the sort of landscape-led sort of coordinated envelope within which the development will sit.
And just having a brief look at the development framework plan, it's called document 1.3. Those, sorry.
Yeah, sorry.
No, not at all. Those yellow asterisks that we've talked about, they are, they're showing a desire or a preference to connect into the private public right of way, but again, that's not being fixed at this stage.
Well, I suppose it speaks to the sort of status of this as a plan. I mean, I wouldn't like to have the impression that all bets are off at the reserve matters stage. The development proposal is put forward and is to a certain extent being assessed on the basis of the design and access statement and this framework plan, which shows the broad principles for the development of the site, and that includes this general arrangement and sort of proposals for how the site would be designed and developed. So there are some very important principles that are on this plan, including the permissive path and the way that the public footpaths integrate and align, etc. But obviously it's subject to reserve matters. Yeah,
and based on this plan, the public open space is, as a matter of fact, situated on the furthest point of the site away from the existing settlement.
It's on the northern side, yes.
Yeah. And you would have to go either use one of the existing public rights of way, and if those connections do come forwards, but for the time being, if those connections for whatever reason weren't to come forwards, you'd have to go through the new development in order to get to the public open space.
Yeah. And obviously, there'll be connections and cycle routes and footpath routes through to the public open space
And
part of the scheme.
just as a matter of sort of principle, I don't think you need to go there. Fine. Okay. Biodiversity net gain, please. I think we should deal with this very briefly. We agree, don't we? There's a legal requirement to provide biodiversity net gain now, and we're not. There's nothing being conditioned as part of this appeal beyond the legal requirement that will be implied into any grant of planning permission.
No.
Your proof talks about the assessment which shows the potential for 10.59 in habitat units and 38.11 gain in hedgerow units. But again, that's not being secured, and that might change as a result of detailed design. That's a potential to provide that.
Of course, it won't be less than the 10% requirement. But,
of course.
But yes, that's an illustrative calculation based on the scheme as designed at the moment. Obviously, there would be a full biodiversity gain plan submitted that would help the full calculation post-permission.
Yeah, and accept the questions that were put earlier that biodiversity is a benefit and 10% is a benefit, but obviously, again, we're going to sound like a broken record, more of a good thing is a good thing. And so more biodiversity net gain would be better. 50% biodiversity net gain would be better than 10%.
Yes, which is why I've given it moderate weight in the planning balance and not significant or substantial.
Yeah. Fine.
And indeed, that, as we were saying earlier, that was, in all honesty, I didn't go particularly to town on that and my justification around moderate on that because I thought it was common ground. So I only was really trying to focus on my evidence of justifications around things that weren't in common ground. So yeah, I mean the inspector will have to form his judgment on that, but and apologies, I've not put a lot in my evidence about the justification at the moderate level because I just assumed it was an agreed. Oh, it might still be. Yeah, it might be still the agreed position. So yeah,
yes, because you were
going to check what the council's position was.
That, weren't you?
Yes,
Yeah.
we will speak to it.
I mean, I think in fairness, I opened on the basis that it was going to be given limited weight, and so that is the basis because we're adopting the evidence of our professional planning witness. That is a departure from the statement of common ground, and no doubt Mr. Hawley will have something to say about that in closing.
Yes, that's your position. Yeah, I understand that. Yeah. So I don't need anything else. That is your position. Yeah. Okay.
Yeah, and you know, the overall scheme of things, as I say, you know, it's a minor adjustment.
Otherwise, yes.
Yeah.
I understand.
Well, in reality, if it was put to me, it was limited. I don't know. I might have formed a different. Might have been willing to agree that with the council at that point in time. But I was involved as well in writing the statement of common ground, and we put in specific weightings to try and agree with the council, not just on ecology and B&G.
Maybe they just missed that one.
Yeah, maybe they did. Yeah.
Sure. Yeah.
So I don't know.
Right. Fine. Yeah.
It'll be fine.
A final point on benefits, developer contributions. I mean, you said as much in proof. You didn't attribute weight to this as a benefit in your proof of evidence, did you?
No, I didn't. No, I got some sympathy for the principle of the point, which was being put to the council's witness that, you know, a mitigation can have benefits to the wider population beyond just the mitigation effects it's having, which the council's witness didn't seem to accept. I would suggest that could be the circumstances, and it could indeed be the circumstances for some of these. I've not weighed them in the planning balance, and I haven't seen the necessity to do that. And
you haven't seen the necessity to do that.
As I say, my tilted balance is not finely balanced in the way that the council's witness has suggested his planning balance is so finely balanced.
Ultimately, even if we accept the principle that yes, there might be some benefit. So the principle is, of course, that a Section 106 obligation is designed to mitigate the harm that arises from the development. Otherwise, it wouldn't meet the tests.
Yes.
But out of that, you might get wider benefits, which go for people beyond the occupiers of the development. Even if you accept that as a principle, you still have to then reach a conclusion on what what weight, if any, to give to those benefits, and the conclusion that you reached in your proof was to not give any weight to those benefits here.
I don't think I've really grappled with it, in all honesty.
What are you saying to the inspector now, having heard? I mean,
I don't think you would give it probably much more than some limited weight, but the inspector could weigh that further in the planning balance. I don't think it would be unreasonable for the inspector to do that if he felt on his own judgment they were a benefit. I haven't relied them in my planning balance to get to a significant balance in favour of the development.
Okay. Bringing all of that together then, as we agreed at the beginning, the inspector needs to consider whether the harms significantly and demonstrably outweigh the benefits, and can we agree that that's not a mathematical exercise, is it?
No, it's a judgment based on information and evidence.
Yeah, it's an overall judgment having regard to all the factors that we've been discussing this afternoon.
Yeah.
Thank you very much, Mr. Tate. I have no further.
Any re-examination, Mr. Hawley?
Yes, there is, if I may, sir. Might I ask if Mr. McGarrity could provide that EHO letter again to the inspector on the screen? Thank you.
Thank you. Yeah. Yeah.
So-
CD, what is it again?
3.14, yes.
3.14, yeah.
So,
Yeah, and you're going to send that to the case officer. Yeah, sure. Carry on.
so this is what Mr. Tate read out, in fact, sir, when he was asked a question, the bit under external levels, in terms of the discussion about why we ended up with an acoustic fence.
Yeah.
And what the EHO said, the letter concludes that the external amenity areas will meet the recommended guideline levels, i.e. the garden, if the existing 1.8 metre garden fence is retained. And we've had that back and forth about retention of that. And the EHO said, in order to continue to provide that function, it needs to meet certain specifications. Basically, it shouldn't have any holes in it, which again is pretty much common sense. And therefore it might be prudent to secure by condition an acoustic fence or barrier, and that of course is what the appellant was dealing with until such time as the council produced its evidence to the appeal and was talking about the northern facade. So Mr. Tate, we have obviously discussed yesterday and today about different potential, the moving parts of the access road, and we've got the access road that can move, an agreement between both parties that moving a noise source away reduces noise effects.
And there are examples of that in the appellant's statement of case that explain there were alternative alignments for that road.
Yep, and potential locations for an acoustic fence.
Correct. You wouldn't put it next to the boundary, you'd put it next to the noise source.
Yeah, and we have prepared a condition which I appreciate the council have only just seen, and the inspector hasn't seen it. But as part of the reserved matters, is the appellant tied to the noise assessments that have been done to date, or can the appellant undertake a specific noise assessment for whatever scheme is proposed?
The condition as worded requires the submission of validation for that, its performance to achieve the noise levels.
Yeah, and in terms of the assessment of the noise effects of the scheme, we know from our discussions yesterday this idea of the worst case, that the only comparator has been the noise data from Queenborough Road and the Wardle Armstrong work, which is 30 mile per hour road, assumes all combustion engines, etc., etc.
Correct.
Now, in terms of the reserve matters and dealing with a condition that specifies acoustic levels, if a new assessment is done, would it be open to the appellant to get more accurate information to inform that assessment as to what the actual effects would be?
Well, of course, you've got a detailed design at that point, and you've got the ability to do proper detailed surveys of what actually the noise will be.
Yeah. And from what you've heard from the noise witnesses, you know, taking this scenario we've got at the minute, that it's a point source which is placed at the very closest point to the receptor, 11 metres away, and it's a point source which is modelled from a 13 mile per hour road which has an 85th percentile average speed of 29 miles per hour and assumes all combustion engines and is a through route, not accessing a residential route. If those assumptions were to be revised, where in your view would the effects likely go?
Well, at the end of the day, it's not particularly my view. I mean, that sort of questions were put to the noise witnesses to say if it was to move further away, would it you know, have the potential to address the noise issue? And I think both noise consultants said, well, yeah, if you move the road further away, you know, the doubling of distance ends up in half the noise, and the noise barrier could go next to the road, and it could have a substantial difference in terms of the noise implications. So I think, you know, in fairness to the council's witness, as he said in his evidence, he thought it was fixed, so that's why he assessed it on that basis. And that was the, you know, that's, again, it's no criticism. That was what was on paper at the moment in time he was preparing his evidence. But obviously, subject to reserve matters design and the details of the fence that would be designed at that point in time, it can be fully assessed and controlled. And if there's issues with it at that time, then the development won't proceed until it's correct.
Okay. In terms of the weight to give to certain matters, there was a theme in your cross-examination about. So it started with housing shortfall. You know, well, what if we were in a district of 1.5 years? And I appreciate you went to, well, actually the number of units is important as well.
Yeah.
And then the point about affordable housing. Well, 100 affordable homes is better than something less than 100.
Yeah.
Or 200 market homes is better than 100 market homes. Yeah.
Yeah.
There's a bit of another twist element to that. What do you say about that approach of saying, well, I temper down the weight I'm giving to whatever this proposal is, because there might be a proposal somewhere else for more?
Right.
What do you say to that as an approach? How would that work in terms of scales? Oh, well, this is for 200 homes, but there could be a scheme somewhere for 300, so I can't go to my top scale. This is a scheme for 400 homes, but I've heard there's one of 800 somewhere, so I can't go to my top scale.
Well, I mean, you can only really deal with what's in front of you at the time, can't you? And I don't know whether other schemes are coming forward. All I know is that the council have got a shortfall in housing land supply, and they are, you know, massively needing more affordable housing delivery. You know, and you know, there will be, you know, a take-up of these affordable homes that are needed by people in the district who don't have an affordable home that they can access at the moment. So all you can deal with is the development that you've got in front of you at this point in time and deal with its merits. There may be something that comes along the line later that would be different, but I'm dealing with known knowns, and this is my scheme, and the scheme has a number of dwellings that are proposed to be affordable. There are a significant number of dwellings such to afford the substantial weight to the benefit. And it's not, like I said, it's not just about the number. It's the factors, you know, you could have a number that would be quite a large number, but in a different authority where affordability is not so strong, that you might not give that number, a higher number, so much weight. But I think you've got quite a lot of factors that come into play here that all speak to the weight to be given to that affordable housing, that include the number, but also include other factors around affordability and delivery of affordable homes and need for them.
Oh yeah, the known knowns point.
The known knowns.
This is Donald Rumsfeld.
It is, yes, it is.
Yeah. That's not
I didn't invent that one.
Americans. Yeah.
Okay.
Dangerous. Yes. No, I know what you mean.
And just in terms of that, you know, we've had some back and forth about percentages and what value they provide for us. You were taking to examples of 100% affordable housing schemes.
Yes.
How helpful is it to look at percentages in that context to say, well, in isolation, an 100% affordable housing scheme would be better as compared, you know, a scheme for 20 units, 100% affordable. What weight would you give that as compared to a market scheme that has a policy compliant 30% for, say, 100 units?
Yeah, well, I mean, I think you've still got to look empirically at the number of units that are being provided. I think, you know, as a factor, the number of units being provided is one of those factors that's important to consider.
Okay. And then just lastly, I appreciate the word standard was retracted, or typical benefits, I think it was referred to. We have an example of where one looks at benefits in a specific balance in the framework. In Greenbelt policy, when you haven't managed to pass through grey belt, and you are inappropriate development, you need to demonstrate very special circumstances.
Yeah.
Do the package of considerations making up a successful very special circumstances case need to be out of the ordinary, or can they just be ordinary circumstances?
Well, they could be ordinary circumstances, couldn't they? And you could have a series of ordinary circumstances that amount to very special circumstances, couldn't you? So they don't necessarily need to be exceptional. But they obviously, you know, one on its own could be combined with others that create very special circumstances, couldn't they?
And just lastly, in a similar vein, in terms of the economic benefits that you set out those at 4.23 of your proof. Okay, you heard me speak to Mr. McGarrity and, you know, about various different hypothetical schemes, and he said, well, this isn't an employment scheme.
Yes.
In terms of the things that it's generating. Okay.
Yes.
We've got a housing scheme here that will contribute just shy of £18 million to gross domestic product. It will result in 98 full-time equivalent direct construction jobs. Are construction jobs skilled jobs?
Normally.
Yeah. It will add a potential 133 full-time equivalent indirect jobs, i.e. in the supply chain.
Yes.
Okay, none of that is disputed, is it?
Yep, correct.
All right, so if there were a proposal here for Sainsbury's to open a store in Malden, and they were saying, I'm going to contribute 17.9 million to GDP, I'm going to provide approximately 98 full-time equivalent jobs, and in my supply chain, I will also add a potential further 133 full-time equivalent jobs. Would you consider it appropriate or inappropriate to say, that all sounds lovely, but that's no different to any other Sainsbury's anywhere else? So I'm going to have to temper the benefit of those economic benefits.
Yeah, you wouldn't temper the benefits, would you? Just because it's it's the same as another supermarket.
Yeah. Thank you very much.
Okay, thanks very much. You can sit somewhere else now if you want. It's 4 o'clock. So so on Tuesday, we're going to start at 10 o'clock, and the of course the council has to arrange the meeting. Yeah. Yeah. Say 10 o'clock on Tuesday morning, and so we'll deal with the conditions, and then we'll deal with the 106, and then I'll hear the council's closings, and I'll hear the appellant's closings, and obviously we got the whole day if necessary, so it'll be fine, won't it?
I don't propose to spend.
No. But we, you know, if we go into the afternoon, absolutely, no problem. Yeah. So yeah, if you just send the link to the case officer, and you'll send it to me, and I presume you use Teams, do you? Yes. Yeah, great. Is there anything on?
And that will also be streamed online.
Oh, okay, fine. Yeah. And the streaming's all gone fine, has it?
It's all been fine. We
Yeah.
haven't had any-
Yeah. Yeah. Yeah, yeah.
Streaming's all gone fine.
Oh, great.
No members of the public have said there's been any issues or anything.
Okay, so, and that will be streamed too then. So, I'm not waiting. So I've got the 106, the agreed 106, which is unsigned and undated at the moment, but there won't be any changes to it, will there? No. No, okay.
Unless you've had any comments about it, sir. Obviously, we haven't heard your or any feedback from yourself.
Well, I haven't given it any massive thought. I mean, I've read the summary, and what I thought about the summary was, I don't fully understand what the blue pencil clause is, because I didn't read it in any detail.
We can explain that.
But you can explain that.
On Tuesday, but
Yeah,
and the reason why it isn't signed obviously is
Yeah, yeah.
after that session.
Yeah,
If everybody's happy and there's no
yeah.
sort of obvious points that comes up, we'll get it signed. I think we said a couple of weeks would be ideal. You said that.
A couple of weeks would be ideal,
Yeah.
but well, obviously that's up to you. I mean, the sooner the better, obviously, because I'm intending to write this up as soon as I can after Tuesday. And if it drags on for longer, then it may be delayed further. That's all. So, yeah. Well, that's all there is to say, then, isn't it? There's nothing else. So, yeah. Here's your laptop back. Thank you. Thank you very much. And yeah, you are going to send that to the case office.
I think it's already been sent.
Oh, fine.
Yeah,
Great.
myself and I believe the attendants have already done it.
Oh, and then
They will have it twice.
the case officer can upload it onto my SharePoint files. Okay. Yeah, thanks for giving this to me. Yeah, I will. The case officer said, could I post it back to you, because they're precious, apparently. Yeah, and I will do that once I've written the decision. So yeah. So I'll just post it back to you. Right. Thanks for your help, everyone. Thank you very much. Yeah, as I say, I'm going to write it up as soon as I can, and so as soon as I get the 106, then I'll be able to issue the decision. So, yeah. Okay. Thank you very much. 4 o'clock. Yeah.